Senators, the committee will resume. Attorney General, we are at clause 6(2). Yes?
Thank you, Madam Chair. Madam Chair, we had the opportunity over the lunch break to do some further drilling down. The advocacy on the part of several senators, led by Senator Ramdeen, is very welcomed. The opportunity to treat with a clear indication of heavy criminalization for a gang leader within the context of 6(2) is very welcomed. That's driven specifically by the fact that the discounting of sentences is an automatic event in certain circumstances. If there's an admission of guilt, there's a 1/3 off immediately, so that 25 years becomes 15 years. And if there is time to be counted, if you enter a plea of guilt immediately, the sentencing direction is that they cut off 1/3 of your sentence automatically. So if they say 30 years, you're getting 20 years. If you then calculate what a prison year is versus a calendar year, a prison year is 9 months, 8 months. And therefore, you are not actually doing a full year. So when you apply the discount, even before we get to whether they ought to consider your pretrial incarceration in softening the amount you get, you may very well find that a 25-year sentence is actually 5 years. That's the reality. The difficulty that we had is that this law provides for a sunset clause, and therefore the arguments proposed by Senator Choate come to life, whether one can argue that the law is disproportionate because Parliament intended to gauge the proportionality and efficacy of the law by the prescription of a sunset clause. So whilst it's very persuasive to have the natural life indicator, and for the record, natural life doesn't mean that you get natural life on every occasion. It is merely a maximum sentence indication, and the court has the discretion to apply anything under that depending upon the circumstances. There's a further due process in that you can appeal the severity of sentencing, so therefore there's another safeguard on that basis. Unfortunately, I don't have a position from the Cabinet with respect to this view, and the recommendation that I got in the round was that we should improve the term of sentence. The highest that we've seen so far is 30 years. Doesn't take us much further from 25, but it's 30 years. And then, specifically with a view to amendment on a further occasion, we could either treat with it by way of a return to Parliament before a sunset period, or at the sunset period, which is prescribed in this law, look at it again. So,
yes, before you put that, AG, given the submission made by Senator Choate that we could always come back and revisit 6(2), and then with the changes she recommended to 6(3), may I respectfully suggest that we stick to what we have in the legislation and do not add any numbers in terms of what you were proposing, 25. Are you proposing in 6(2) we go from 25 to 30?
Yes.
I would like to respectfully ask you to leave what we have now as is, and in due course, because of the sunset clause, we will come back during that time and revisit the number. Could I respectfully suggest?
Sure, Madam Chair, I'm desirous of achieving consensus. So it was a proposal insofar as there were two very informed and persuasive points of view, which I think have merit on both parts. So in those circumstances, if the consensus is for maintenance of the clause as is, then I'm prepared to leave it there. I do wish to put for the record, then it's from a personal perspective, that I think that there's a lot of persuasion to the argument that we move as far ahead. I don't think that people have counted the discounting factor, and in fact, the judiciary has published its sentencing guidelines, so this isn't a speculative thing. This is a well-established, published position from the judiciary of Trinidad and Tobago, but I would want to do a little bit more research on it, Madam President.
All right,
Madam
so
Chair.
that from my understanding, therefore, clause 6(2) will remain as is and be put to the vote as 6(2), but not just yet because we have further amendments to the other subsections. Clause 6(3), Attorney General, we had some consequential amendments to be made to clause 6.3.
And we propose, because of further submissions, that there be a further tightening. Would it be convenient if I were to provide you with the suggested draft? We propose that the language in 6.3 be replaced by the following words. A person who commits an offence under subsection 1b, C or D is liable, in the case of a first offence,
Just one sec.
yes, is liable in the case of a first offence, on summary conviction to imprisonment for 10 years and, in the case of a subsequent offence, to conviction on indictment, Madam Chair, on conviction on indictment, for 20 years, to imprisonment for 20 years. Yes. So that will be on conviction on indictment to imprisonment for 20 years.
Yeah. May I read it now?
Yes, please, Madam Chair.
A person who commits an offence under subsection 1b,
Yes.
C, or D, is liable in the case of a first offence, on summary conviction to imprisonment for 10 years and, in the case of a subsequent offence, on conviction on indictment to imprisonment for 20 years.
Should it please you?
Yeah. Any comments, please, before I put this particular clause to the vote? Yes, Senator Ramdeen.
Madam Chair, through you to the Attorney General. Is it that the same concern that I had at the outset, Attorney General, doesn't seem...
Is it migration to indictment on the second one? So I was balancing the two perspectives. One, it was the old law, and because it's more severe, the indictable route and the concerns of excessive criminalization, and then my own position that nothing ought to encumber a summary court from treating with this automatically. So the views of the Senate are welcomed on that purpose. I think that if I were to narrow the issue squarely, correct me if I'm wrong, Senator Ramdeen, it's removing indictment from the second occasion, correct?
Well, I would have thought that the intention of the government would have been that if you are pursuing the policy that a second indictment is something that is deserving of more severe punishment, that whether it be on indictment or on summary, that you would have the same policy applied to both as a matter of equality in terms of the application of the policy. So I would have thought that where we are drafting, it seems as though you're accepting the policy position, correct me if I'm wrong, that you are catering for someone who is convicted a second time.
Yes.
And if that is the position of the government, then I would want to suggest that we apply it equally across the board if it is a summary conviction or an indictable conviction.
So keep it as summary is the suggestion?
No. I'm saying if your policy
yes.
is that you are accepting that that
I understand
conviction
what you're saying now.
On a second offense.
If you start one way, continue the other way. So if you start indictment, go indictment. If you start summary, go summary, or either way.
Either way.
Yes.
My position is across the board that we don't give a benefit to somebody who is convicted a second. The way it seems here is that somebody is convicted a second time on a summary offense under this act is not attracting the same punishment as a person who is getting a second conviction on indictment. So all I'm suggesting is that let's treat it equally, that whether you are going summarily or indictably, that a second conviction is one that warrants a higher degree of punishment.
Sure. Madam Chair, just to explain why the policy has come this way, because there was a consensual policy in the House between opposition and government. So I came with that policy, which was agreed, because there was some difficulty in settling upon an agreed version. If the recommendation here is that we simply remove conviction on indictment, to subsequent conviction, we could take off on indictment to imprisonment for 20 years. I would personally welcome that, but I am guided by the consensual view of the House, this House. Senator.
Before I call on Senator Ramdeen, Senator Roach.
What I would like to see, Attorney General, is that notwithstanding the consensus in the other place, if it makes better sense and is more efficacious, it makes for efficacy, why not do it? Sorry?
I'm reminding that I don't make law for myself. And in this House, I'm hoping to hear the views expressed of honourable senators. So far, I've had my view and Senator Ramdeen's view. Thank you, sir. So there's agreement. Are there any? Madam Chair, you are the chair, so let me not usurp your function.
Does anyone else have a comment? So, Honourable Attorney General, is it that you're going to further amend?
Should it please you, Madam Chair, I would
Yeah.
propose that we delete the words on indictment.
Yeah. Right, take off on indictment, second, yeah. Yeah. All right, so Honourable Senators, permit me to read Clause 6.3, the amendment, and then I am going to please be allowed to put it to a vote. I see Senator Ramdeen wants to make one further comment.
There's something small, Madam President, is that
Yes.
having regard to the suggestion by the Honourable Attorney General that we take out the words on indictment, and the clause is phrased, premised upon a summary conviction, whether taking out, whether it's enough, Attorney General, that when you take out the words on indictment, that it would apply to someone who starts off on indictment and to a second conviction. I just want to make sure that we have it correct. If your drafters are satisfied with it.
One B is
Can I suggest that we may be able to achieve it, subject to what the drafters say, by actually taking out the word summary?
The mischief that you're pointing to is whether there may be an indictable matter which could cause non-equality of treatment. Yeah, in the ABC. But B, C, and D, gang member, professing to be a gang member, the act of initiation, those are offences which are summary.
You don't want to consider splitting it and doing us reformulating the section by saying, you draft sometimes in such a way that you say on summary conviction to X, on indictable to X, and then for a second, you provide for a second conviction separately. That might achieve a neater way of drafting it. Well, what you would have to do is you would end up in the position of having to provide suitable punishment for the indictable on the first time up.
3 was treating with the identification that if you're going to be charged for an offence under as being a gang member or initiate or pretender, that trial would be summary. So 3 treats with the mischief that is intended by the drafter's language here to be caught is to clarify the position as to the manner in which you proceed, summarily in this case. The
But then how do you get to if that is the position, then you run into the problem of how do you get a second conviction on indictment if you can't start off with indictably in the first place.
So the drafter's view on this is that the second conviction giving a 20-year jump, that should have been heard indictably. This was the language of the old act. So you're caught on the summary route for the first occasion, but when you get a second charge against you and you're convicted, then you go for indictment to suffer the larger and enlarged position. That was the drafter's structure from the old 2011 Act.
Respectfully, AG, I understand that may have been the position. I don't want to be bound by what was there before.
Yeah.
But would we not have to provide?
Just 1 second. Testing, 1, 2, 3. Could you please test it and turn it off? Please. Senator Ramdeen.
Yes, please.
Because of the way in which the section is actually drafted, being that we create the offense under 6.1, and what you are doing subsequently is providing the sentences in different ranges for the different offenses that are created.
Yes.
I think it would be more prudent in relation to this B, C, and D that we provide for them separately and let the law take its course, so that if we've created the offenses under 6.1, let us create a section. It may require that you have an additional section, but let us create a section that deals with summary conviction, create a section that deals with indictable, and then do a section that deals with the second offense. The second offense will apply to whether it's summary or indictable. But what you will do is, having created the offense under 6.1, you will be able to provide the penalties separately. You would still achieve your summary because you want to keep that, and you will still be able to charge someone. Why not allow the prosecuting authorities to decide whether they go summary or indictable? And you will still achieve your mischief, which is that you'd have a section that deals with a second offense that will give you a wider catchment of summary and indictable.
Just give me a moment, because the drafters are wrestling with the submissions at the same time, notwithstanding our views.
Okay, honorable senators, I think that listening to the discussions, I think we should defer clause 6, and we will come back to it. Let the drafters and the Attorney General treat with it. Yeah. Close. No, the whole of clause 6 I'm going to defer.
Madam Chair, I just want to ask one question so that I'm certain whilst I'm drafting in the stand-down position, through you to Senator Ramdeen. Would it suffice if, is the mischief only on the second limb, the second conviction? Would it be within consideration that we go either way? So we agree that gang member, initiate, and pretender, those are summary offenses. You go in. Your second round, liable on second conviction, where we bump it up, would it meet within, would it be passing muster if we were to say that that is an offence which is triable either way?
No, I think that what you want is you want to start off either way and end either way. If respectfully, if you could put couched in those terms, you want to start either way, so that if you start on indictment.
Understood. I just wanted to be clear so that we're formulating.
All right, so Honourable Senators, Clause 6 is stood down, is deferred? No, 6, the entire Clause 6. Yeah.
Can I just suggest, if we're going to stand it down, could we just suggest to the Attorney General what may be the position with the other subsections, so all can be considered in the stood down?
Okay. So Clause 2, we have agreed to Clause 2, 6.6.2. Clause 6, Subclause 3 has presented some difficulties. 6, Subclause 4. The Attorney General had submitted an amendment. Without going into too much detail on that amendment, because really we need to be a little more efficient with our time, is there an issue that you're seeing with the amendment? Senator Ramdeen, just broadly.
Attorney General, while we are creating a serious offence punishable with 25 years here for a member of a law enforcement authority, the difficulty I have with is the person who is involved in intelligence gathering, because that person is not a person that is defined under the Act. And whilst you might say that we can use the literal interpretation of that, where you are creating an offence that is caught by someone involved in intelligence gathering, I think that we need to, I think my first position is that it is too wide, and secondly, we need to define so people will know who are the potential group of persons who are going to be caught by this. The first part of it, law enforcement authority, you've cleared that up, or we've cleared that up before. But the second part, I think, we have a little difficulty with.
Sure. Madam Chair, the rationale, the policy behind intelligence gathering and the reason why we didn't define it. So when we looked at the structures of the security intelligence services, intelligence gathering involved secondment or contract positions in the SSA legislation for elements that would provide the human intelligence or interception evidence which would bring convictions forward. From those purposes, specifically because the SSA Act, as an example, as a funnel, as a filter, provides for public officers and contract officers and secondment of customs, TTDF, and immigration, we had a problem in formulating it. So we did rely upon the literal interpretation, intelligence gathering. They would have to satisfy the court that they were caught within that literal interpretation, be it persons who were planted into gangs to retrieve evidence, etc., persons who had turned and given evidence and were within the umbrella of assistance under the SSA formula in particular. So for those purposes, we couldn't define it too narrowly because we didn't know how the intelligence aspect would work its way out in terms of protection. Again, because this is a penalization aspect and also a benefit asset when we come a little bit later down to retaliatory action, we felt that we could have relied upon the literal interpretation.
Attorney General, I think is very, very, I am one who is proposing that we be more stringent about these things, but I think is very, very wide to catch a person who, you're saying this is like someone who works a servant and or agent of law enforcement.
Attorney General, I think you've heard the concerns of Senator Ramdeen. Because we are going to come back to Clause 6, I think we should move on. And
are there any other concerns on 4, Madam Chair?
It doesn't seem so. I've given members an opportunity. Okay. And let us just deal, therefore, briefly with the proposed amendment to Subclause 5 circulated by the Attorney General.
So, Madam Chair, in 5, with that which has been circulated as C of the list of amendments, we're just adding on after the words under 5A, the word or. That is, after the semicolon, put in the word or, And we did this in terms of recommendations coming from the Law Association, that we have a separation out. And we did specifically so because of the recommendation of Senator Choate that we migrate away from the formula which was used before, that is the unlawfully and maliciously, and instead use with intent. So these amendments come from two sources, both Senator Choate and the Law Association.
Does anyone want to flag an issue for the Attorney General before I move on to Clause 7? Very well. So Clause 6 is deferred.
Clause 7.
Honourable Senators, the question is that Clause 7 stand part of the bill. Honourable Senators, an amendment has been circulated on behalf of Senator Shriki to Clause 7. Senator Shriki, I will therefore allow you first to indicate the reasons and purpose for the amendment.
Thank you, Madam Chair. Madam Chair, through you to the Honourable Attorney General, Clause 7 deals with membership as well, and the words used to describe, well, in the clause, a person who coerces, encourages, entices, aids, or abets another person to being a gang leader or gang member. And my proposal is that if we can consider the word facilitates in addition, as that too can be a way in which members are recruited, where through one member, another member is admitted to the gang. And that's the purpose of using the word, or suggesting that we use the word facilitates.
We were relying upon the literal interpretation. One of the synonyms that pops up for encourages is facilitates. So if you look for a synonym for facilitate, you'll see encourage. So we feel that it may be superfluous, but we do understand the context in which the submission has come. It's laudable, but we believe that it's courtier, in particular because we've also used aids and abets. There was some observation as well about the accessories law that we have, which allows us to get into aiding and abetting within the context of our known law. So there's standalone legislation to that effect, which also has some degree of assistance to this, as well as the Interpretation Act. So that is the Accessories and Abettors Act, Chapter 1002, and the Interpretation Act as well.
If you think that is sufficient.
We believe it's covered.
So are you withdrawing your... So Senator Shriki has withdrawn his amendment to Clause 7. Senator Mahavir, you wanted to say something?
Yes, thank you, Madam Chair. Through you to the Honourable Attorney General, I see one sentence, Honourable Attorney General, 25 years. But I see what I consider to be two offences. And if you were to read, it says a person who coerces, aids, or abets another person to be a gang leader. And I think that offense of coercing someone to be a gang leader is quite different from someone who coerces someone to become a gang member. Because I see someone coercing someone to become a gang, or encouraging someone to be a gang leader as a Mr. Big, as it were, someone who is somewhere far removed from the scene of gang activity and is actually inducing individuals to become gang leaders. And he's outfitting them, he's financing them, equipping them, doing whatever is necessary to lead a gang of a number of persons. And he is getting the same 25-year sentence as the leader then who goes about and recruits a 15-year-old to become a gang member. And I am wondering whether it would not be in the public's interest to have a more severe sentence for the individual far removed from street gang activity, taking up from Senator Choate and, of course, from Senator Ramdeen, someone far removed who is actually encouraging someone to become a gang leader or gang leaders, to have maybe the natural life sentence, because I consider that to be a serious, or an offense more serious in nature than someone who is recruiting a 15-year-old only into the gang. So I get your views, but I would recommend a stronger sentence for the person who is recruiting gang leaders.
Attorney General, just hold on. Any other comments?
can I just be allowed to support Senator Mahabe on the basis that in the previous section, we made the distinction in terms of the gang leader and the gang member, the B, C, and D. And therefore, you may want to consider in line with your policy with respect to 6.1. Remember, we prescribed separately for the gang leader. I was going to, before Senator Mahabe raised that point, I just thought that it was very, very meritorious having regard to what you did in 6.1. And I think that not only on policy but practicality, it must be a more serious thing to encourage somebody to be a gang leader than the point that Senator Choate had made earlier, that there are people who are lower down who would be the gang members. So I want to join Senator Mahabe in asking for it to be distinguished.
May I invite any further comments on Clause 7 before I... Senator Richards.
Thank you, Madam Chair. Just a question to the Honourable Attorney General. If these phrases, inclusive of coerces, encourages, entices, aids, or abets another person, are following from what Senator Choate's contribution was earlier on, and I think Senator Ramdeen, does this cover financial support?
Yes.
It does?
Yeah.
Thank you.
Senator Hussain.
Thank you very much, Madam President. AG, I just want a point of clarification with respect to this section that we're dealing with 7. What would be the difference between coerces, encourages, entices, aids, or abets from recruiting a gang member? Because I see that recruiting is a separate offense.
One may be a softer shade of the other. Recruiting involves a more deliberate involvement, perhaps a more ritualistic and perfectioned sort of approach. The other one may be something a little bit further removed. So it was intended just to catch the degrees of positions. We've also borrowed from a number of laws where the concept of aiding and abetting and facilitating is treated separately from recruiting. And so we've maintained with what other jurisdictions have, as well as the previous law.
The reason I ask is because I think it might be a blow for the police officers themselves
It certainly is
to
one.
determine which section to charge under,
It
because
is.
they're so similar.
I think it may very well be that you may be looking at multiple charges under different sections. As you often hear in a scheme, somebody was hit with 354 charges because they get hit on any one of them. So you're correct that there may be quite a blue.
Yeah, thank you.
Senator Creese.
I don't know if here is perfectly relevant, but what I was concerned about, and I think most citizens are, is the internecine gang warfare, and whether this could address it or whether it is addressed somewhere else, because a lot of us are, in effect, innocent bystanders to rivalry between gangs.
Just 1 second. That's okay.
It is difficult to be torn in 3 different directions.
Sure.
At the same
Senator
time. I
Creese
apologize.
just raised the issue about gang warfare, and does this clause address that issue? Senator Mahabe and Senator Ramdeen. Senator Mahabe and Senator Ramdeen are both of like mind that it needs a larger sentence. Yes.
2 points, a disaggregation and a larger sentence.
Any further comments?
Because of the way in which this section is drafted, you might want to take into consideration that there is a heavy deterrent element in the creation of this particular offense, because it not only it not only is meant to deter persons who, while the gang is already in existence, it really, one of the main things about this particular offense is to deter people who are in the process of actually forming a gang before it is actually formed. So to that extent as well, if we assume that you must have a gang leader before you have a gang, then I think that the disaggregation of it in terms of separate offenses is probably grounded in a public policy deterrent element as well.
Attorney General.
Sure. Madam Chair, there are a few thoughts that make the circumscription suggested by my learned colleagues a little difficult to manage. First of all, is the word of caution with respect to that which we will agree upon as the maximum sentence for a gang leader to be treated in Section 6. The recommendation coming off of the Senate is in several places. 1, let's go for natural life. 2, let's leave it as it is until we further reflect. 3, let's see if we can bump it up a little bit more. And there is, of course, the underlying caution that Senator Choate has brought, which says you may find that you are treating the most disadvantaged and disenfranchised people in a particular way and may therefore fall afoul of excessive criminalization. Those are the arguments. But from that springboard, in Clause 7, in Clause 10, in Clause 13, we find ourselves wrestling with the same point if we accept or pull at the thread. And those points are 2. It's a bifurcated point. The first limb of the point is treat gang leader and gang member differently because one is more severe than the next. And the second point is how heavy in terms of criminalization do you go? That's the Section 6 argument, the Clause 6 argument. If we accept the caution that Senator Mark has put out, which is, look, leave the 25 years as your top penalty as is, then we are at the current version of natural life, if I can call it that. We're at the maximum end of where we are right now, and at sunset clause or prior, we can treat with this otherwise. So if I treat now with Clause 7, with respect to the 2 limbs, disaggregate them, leader and member, and that point only, forgetting what the sentence should be, not 25 or life or otherwise. The disaggregation can work, but also to maintaining it the way it is because it's going to appear in other sections can work as well. 1, the maximum sentence of 25 years is a prescription which is just maximum sentence. So the gang member may get the lower amount, the gang leader may get a lower amount, or they may get the same amount. Parliament will not have drawn a difference between the 2. But what I'm having a difficulty with right now, and I genuinely appreciate the contributions of honorable senators, is that in coming to this House and being circumscribed by the manner in which we came here, i.e. passing through the House of Representatives, etc., the difficulty in now disaggregating causes some complication. On the floor, on the trot, as we do now, is going to erode the entire fabric of where we are. Clause 7, Clause 10, Clause 13, right through. And what I fear may be the result is a little bit more confusion than we expected. In those circumstances, I'm minded to accept the caution of Senator Mark, which is, let's take this with a little bit of caution, let's look at this with some more reflection, and let's come back, particularly as we are coming back in a very short while. 30 months is not far away, whomever brings it back, if not prior, because I can tell you that the government does intend to come and treat with criminalization and benefit for all of law enforcement in a bill very shortly, where if you're a prisons officer or a fire officer or a police officer and you are promoting criminal activity, heavy criminalization. Also heavy benefit if somebody messes with you or your family in certain types. So we have a potential consequential amendment that can come about. In the round, having listened to the very good submissions, therefore, I'm minded to ask honorable senators to leave the clause as is, because we're going to be pulling at the tapestry on threads that I don't quite yet know will unravel in a particular direction or not. And in those circumstances, taking on board the very good submissions by all, my learned colleague Senator Ramdeen, my learned colleague Senator Choate, all of the senators so far, I'd ask that we leave the clause as is.
So, honorable senators, the question is that Clause 7 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 7 now stands part of the bill.
Clause 8.
The question is that Clause 8 stand part of the bill. Senator Shriki Soon, an amendment has been circulated by you in respect of Clause 8. And the Attorney General has also circulated an amendment for Clause 8.
Madam Chair, we have adopted the submission of Senator Srikisoon in the circulation of our amendments. I don't know if that would assuage the concerns of my learned colleagues, such as to cause him to withdraw.
So you withdraw your...
In light of the AG submission, yes.
Madam Chair,
Yes.
just a little clarification. Attorney General, in terms of Clause 8.1, right? Instead of saying that a person shall not intentionally, is that the language here?
Yes.
Right. Take any retaliatory. I was just trying to address this in another way. And it goes like this. A person commits an offense who intentionally, right, take any retaliatory action rather than how the language is currently stated. Just for your consideration, you may want to keep it as is, but just a tighten.
Madam Chair?
Yes.
I welcome Senator Mark's suggestion. The drafters prevailed on this particular position in terms of the current manner in which clauses are set out. And for those purposes, I think that we'd really be addressing it in the same way if we were to adopt the formula. I understand where you're coming from, but I'd recommend that we leave it as it is. Okay. I remind that the insertion of intentionality was to address the concern of the Law Association that it not be a strict liability offence as it appeared to be, but which I didn't necessarily agree with.
Okay.
Attorney General, do you wish to elaborate on the new sub-H?
Sure, Madam Chair. The sub-8, as proposed to be amended in the fashion circulated, is intended to take care of the intentionality insertion, that is to include an express reference to a mens rea or mental intention for the crime. And secondly, on the second limb, to take into gear that recommendation from Senator Srikisoon that we address the non-street version of the gang activity, which is the funding activity. So the language to be included is refusing to provide funding or resources to a gang leader, gang member, or gang. And that constitutes the rationale.
All right. So, honourable senators, the question is that Clause 8... Sorry, Senator Ramdeen, you wanted to say something?
Yeah. AJ was wondering whether it wouldn't be necessary for us to define relatives.
We actually looked at that. We saw references to relatives being defined in other laws, where we defined the degrees of consanguinity, etc., and then we took into account the Trinidad and Tobago context of, that's my family, quote unquote. And what we went for here was the broad literal interpretation of relative. We found that trying to put in, we did it recently, Senator Ramdeen, in other pieces of law in the Senate, where we actually defined relative, but we found that it was in relation to victim impact statements when we were treating with the amendments that we did in plea bargaining. However, we found that it became a little untidy here. So what we did was to leave it to the open, broader perspective of relative and left it for judicial interpretation.
The difficulty with that is that it doesn't, it's a dangerous thing to leave it to judicial interpretation, because then you reach the point where you charge somebody brought before the court, has to face a prosecution.
So we have two formulae. I catch your point,
Yeah.
through you, Madam Chair. We have two formulae. The consanguinity and cohabitational relationship narrow definition,
Yeah.
or the victim impact statement version as we did in plea bargaining, which is a much broader version. There were two ends of the spectrum. And therefore, we felt that we should have gone on this route. We were comforted by the fact that Jamaica didn't define relative, which is where this formula came from.
Can I give for an example, just to make it, to demonstrate it? Would we include a stepchild?
Sorry, Madam Chair, if I could, and permit me for jumping the gun.
No, of course.
I'm looking at the definition of relative in the plea bargaining legislation. We had relative means, A, in relation to a victim, parent, step-parent or guardian, spouse, cohabitant, fiancé, child, stepchild or other dependent, brother, sister, stepbrother, stepsister, grandparent, any appropriate person who the court determines, forgive me, I'm unfortunately not using my own computer, so it's a little bit messy. Okay. Oh, I see. So any other, apparently a touch screen. So any appropriate person who the court determines to be of sufficient proximate relationship, whether by blood or otherwise, to be considered a member of the victim's immediate family, or any other person responsible for the victim's care and support. So, so that was the broadest form of definition we could have used.
But you see, that comes, the difficulty that arises is that comes ex post facto, so that the court is able to actually make that determination to capture what the definition says. In this case, you have an offense that is being created. You have someone who is charged with the responsibility of capturing who is caught by that offense.
I'm on the same page with you. Is the recommendation that we include a definition of relative?
I think we should include and take out the omnibus clause. Include it as wide as you can in terms of a definition. Because I'm not sure, AG, that the narrow definition in relation to blood relative is going to be too narrow. I'm clear on that. But I'm not sure that the actual literal interpretation of relative will catch all of the different catchment areas that you want to catch, that you might be able to catch with a definition instead of just leaving it open.
Would the Senate be comfortable, Madam Chair, with the definition that we used in the plea bargaining, as I've just read out?
Save and accept the omnibus, which is any other person that the court deems of sufficient proximity to the last line.
And that would be any appropriate person who the court determines to be
Correct.
Of sufficient proximate relationship, whether by blood or otherwise, to be considered a member of the victims. We could. May I invite views through you, Madam Chair?
Honourable Senators, anyone wishes to comment on what has been said by Senator Ramdeen and the Attorney General in respect of Clause 8? Attorney General.
Impact statement, that's right. Madam Chair, if I could propose then that we do an in-clause definition for relative, because that's the only other, this is the only place that we use the term relative.
I was going to ask you, you don't want to just put it in the definition clause?
Well, we don't use it anywhere
it
else.
Matter, you know, it doesn't matter.
So we have two locations that we could insert this. One would be in the clause itself, a person who commits subsection 1 an offence is liable on, and for the purposes of this section, relative shall be. Just give me a moment through you, Madam Chair. So, Madam Chair, with your permission, subject to your guidance and the views of anyone else, may we stand down this particular clause to propose an amendment?
Well, we can do one of two things. We can stand it down, or Clause 4 has already been deferred, and Clause 4, I think, is the definition clause. And I understand that that is the only difficulty with Clause 8, so that we can proceed with Clause 8 and put it in the definition in Clause 4.
Madam Chair, our drafters are suggesting that we put it in 8 because it doesn't come up anywhere else in the Act.
So is it that we are to stand down Clause 8 as well?
Should it please you?
Yes. Clause 8 is therefore deferred. Clause 9. No.
Clause 9.
Question is that clause 9 stand part of the bill? No one has proposed any amendments to clause 9. Senator Ramdeen, you have a comment?
Well, the AG, I wish to raise the same issue that we had flagged earlier with respect to the gang leader and the gang member. If we resolved that earlier by you leaving it as is. Okay, well then I'm fine.
Any other comment? Attorney General,
okay.
Senator Mahabir.
Thank you, Madam Chair. It's just that I'm reading clause 9 together with clause 13, and I'm seeing some inconsistency. I don't know if I could raise it now, whether I can raise it when we come to clause 13. Or maybe I could indicate what it is I'm seeing. Honorable Attorney General, in clause 9, it states that a person who knowingly counsels, finances in any manner, or otherwise provides support to a gang leader can face a prison term of some 25 years. And that's an indictment, but when I look at clause 13, it says that a person who conceals a gang leader or a gang member, and he commits an offense, and he is liable on summary conviction or imprisonment to 10 years. But a person who conceals, in my mind, is providing the same type of service, if we go back to 9, as otherwise provides support to. Because you see, when I look at 9C, I see we are making a specific statement on finances. So I don't know what otherwise provides support to means except harboring and concealing and providing whatever provisioning he may need. Yeah.
You may get 2 charges. And we're proposing that the 10 go to 15 in another amendment. So you're quite correct. 9D may very well be wide enough to capture harboring, concealing, etc. But we've specifically frowned upon those harboring and concealing in 2 disaggregated manners. But nothing prevents the police from laying multiple charges against you, in which case you'll have cumulative or concurrent sentencing.
I was just wondering, when I looked at it at first glance, I thought that the omnibus clause in D was a bit narrow in terms of it being circumscribed only by the word supports. And you already have a definition, not a definition, but you've already prescribed a certain type of behavior that you seek to criminalize in section 7,
yeah,
which deals with the actual gang leader or gang member. So I was wondering if there was some kind of justification for limiting the omnibus provision, which is the D, to only supports, when what you're really trying, what I think that you're trying to do is to cast a net as wide as you can for persons who are furthering the participation of gang activity. And I don't see that there's any reason why we've left out coerces, encourages, incites, aids, or abets in relation to furthering the participation in gang activity.
Quite correct. What I found as a feature through you, Madam Chair, of anti-gang laws across the board, it's like going back to finding as many offenses as possible off of one activity. Again, I'm coming back to you've got 243 charges or indictments, as the Americans call it, or offenses that you put for. So there tended to be a lot of overlap and blur and duplication in some senses. And on the one hand, there was a breadth, and on the other hand, there was not a breadth, meaning width of scope. So regrettably, again, it's to pull to the tapestry of that which was not only the existing law, but the examples of law elsewhere. What I'm anxious to do in doing the full review, again, the manner of approaching this particular bill in the Senate now is very different from how we got here. I'm sorry to raise it again, but we were circumscribed in the draft that came here because of the approach that was compelled to bring the law here. So again, I'm asking, I take note of the submissions, but I'm asking that for the benefit of passage and in light of the sunset provision, that we actually allow it to stand as it is. I do understand the position volunteered, though.
Okay.
Senator Crease.
Sorry.
Yes, I I thought that there were three sort of platforms on which the legislation was coming at people who were in any way facilitating, gang activity. I thought there was a recognition, and perhaps that's in 13 that Senator Marby was referring to, where there's possibly a lesser sentence, because when we say a person who conceals, we are thinking in terms of close family who have a conscience pang. It is their blood and kin, and the person comes running into the house, police somewhere around the block, and you facilitate them, as opposed to somebody who is seeking out your services, to become part of a gang. And then at the higher level, those who are involved in criminal enterprise and are utilizing the services of a gang member to execute, some activity for them. So I thought that there were three different levels, and the punishment would reflect those three different aspects of cooperation with gangs. So in that context, I was seeing there is need for different levels of punishment.
And we do have it, Madam Chair. So if we look at 9, which is a person knowingly counseling, etc., we treat with the punishment on indictment to 25 years, which is so far our max. When we look to 13, a person who conceals, we've gone on summary conviction, and we're proposing to move from 10 to 15 years. When we go to harboring at clause 12, person who harbors, again, we're going summary, and we're proposing to move from 5 to 10. So we have sought to disaggregate them as the Honourable Senator has proposed, and to treat with them differently. But with respect to the submissions made by my friend Senator Ramdeen, I do understand the origin of the submission, but I'm constrained in the circumstance that this law stands before us now to ask for patience in leaving it as it is as we review further.
So, Honourable Senators, the question is that clause 9 now stands part of the bill. All in favour say aye. Aye. Those against say no. The ayes have it. Clause 9 now stands part of the bill.
Clause 10.
Honourable Senators, the question is that clause 10 stands part of the bill. Honourable Senators, the question is that clause 10 now stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 10 now stands part of the bill.
Clause 11.
Honourable Senators, the question is that clause 11 stands part of the bill. There are two amendments, one on behalf of Senator Shriki Soon and the Attorney General. So two amendments have been circulated. Senator Shriki Soon, may I ask you to discuss your proposed amendment?
Madam Chair, through you, in the interest of time, the Honourable Attorney General, in my mind, adequately addressed the issue in his presentation, so I respectfully withdraw, please.
Withdraw?
Yes.
Honourable Attorney General, would you like to just go through your amendments?
Should it please you? Yes, Madam Chair. Madam Chair, the amendments suggested and circulated in the draft on the part of the government is born as a result of the submissions on the floor and by the Law Association. In particular, Senator Choate had recommended that we disaggregate the usage and the possession of the items which we capture in Clause 11, and that we include the defence aspect in Subclause 2, which we have circulated out. That in one, we're providing that using a bulletproof vest, firearm, ammunition, or prohibited weapon in the commission of a gang-related activity, one commits an offence, or if you have in your possession those items and you ought reasonably to know they would be used in the commission of the offence, we feel that those are sufficiently tighter expressions as disaggregated. With respect to the defence, we're putting it that it is a defence for a person charged with an offence under 1B. That is where you have in your possession and you ought reasonably to know. If you prove that you did not know or could not reasonably have known that those items in possession would be used. So we are reversing the burden as a means of proportional. We're providing the defense as a means of proportionality, and secondly, that reversal of burden is on a civil standard. It fits within Section 5 of the Constitution, which allows for it to be done, and once the burden is discharged, it returns to the prosecution to proceed on a different threshold from balance of probabilities.
Any questions? Senator Richards?
Madam, through you. Mike seems to be giving trouble. Anyway, this is for the Honorable Attorney General. Would it be prudent to include in this clause firearm maintenance parts? Because my understanding is that licensed firearm owners can import parts to maintain their devices. And because the clause has whether lawfully obtained or not, these parts may become part of the machinery used to facilitate gang activity.
Sure. They're caught by the definition in Section 2 of the Firearms Act. A firearm includes all parts of a firearm. The barrel, the trigger, the pin, the spring, all of those are caught. Any part of a firearm, which also interestingly includes the ammunition. Ammunition includes a whole bullet, a part of the bullet, the shell, etc. So they're respectfully caught by the definition.
Honourable Senators, the question is that Clause 11 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Senators, the question is that Clause 11 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 11 as amended now stands part of the bill.
Clause 12.
Honourable Senators, the question is that Clause 12 stand part of the bill. Just 1 second, Senator Roach. There is one amendment circulated, no, two amendments, Senator Shriki Soon and the Attorney General. Senator Shriki Soon.
Thank you, Madam Chair. I give way to the Honourable Attorney General because both amendments are the same.
So it's withdrawn?
Withdrawn, so yes.
Thank you very much. Attorney General, if you could just state the purpose of the amendment, and then I will invite Senator Roach.
We took on board the suggestions of Senator Shriki Soon that we needed to treat with the conviction in a different manner, and specifically to improve the number of years upward from 5 to 10. This was specifically to treat with the difference between concealing, which comes up in Clause 13, and harboring, which comes up in this particular clause. And we welcome this suggestion and have obliged accordingly.
Senator Roach.
Yeah, thank you, Chair. Attorney General, this is more like probably touches on a number of clauses that have gone by and probably to come still in terms of the sentencing. I'm wondering if for tidiness and to put back the trust into the judicial officers, why can't you not have the offense dealt with? I mean, gang-related offenses, gangs and gang-related offenses are quite significant, and they seem to be a scourge on our society. We view it very dimly, and we want to take very strong action and ensure a very low tolerance or zero tolerance towards it. Why not have a range that is left up to the judicial officer to determine, rather than going through 15 for this, 10 for this? You have a range for any gang-related activities between minimum 5 years and 50 years, as the case may be, and leave it up to the judicial officers, as has been done in many cases, to do something like that.
Well, Madam Chair, Senator Roach is quite correct. This touches almost all of the clauses where we create an offence. And the very persuasive advocacy which I share on Senator Ramdeen's part is let's go for the max and leave it to judicial discretion. On the other hand, however, the excessive criminalization argument comes in, and that argument may fit within a disproportional, unconstitutional argument. And importantly, because we have a sunset clause, you may find yourself involved in civil litigation as to constitutionality, which can be avoided. So unfortunately, we've kept the old formula for now, and that old formula is where Parliament prescribes certain treatment in the fashion that we have now.
Attorney General, Madam Chair, with the greatest of deference, I understand what you say, right? But if it is you have a minimum and a maximum, and the judiciary has a discretion in applying this according to whatever it be their policy of sentencing, certainly because gang activities is a dynamic thing, and it will be unfolding. So you may have a suppression of one and then a proliferation of one, and the proliferation of one might be the one that carrying the maximum, it might be one that carrying a minimum of five-year sentence. When the court will be able to see, based on reviewing the cases, number of cases of alike, that similar nature coming before them, to be able to say, well, look, we need to do. To me, it makes much more flexibility. It will encompass and facilitate any sunset clause.
Senator, I understand. The problem that I'm battling is that traditionally this is the manner in which the drafting goes. So the breaking of that mold to, for instance, I personally prefer scheduling. I personally prefer that all offences are listed in one schedule at the back and you prescribe the range on the other side. We managed to prevail in that formula in the securities legislation and other legislation, insurance, etc. But unfortunately, we're not in that position yet. And in the meanwhile, until we work ourselves there, we've got a 30-month window potentially under this law, and we're going to work towards formulation. In the meanwhile, the anxiety is to have the law out for its disruptive purpose as opposed to its conviction purpose. Disruption being the main idea to prevent these things, and then dealing with the conviction after. So I do share the concern passionately, but I'm not in a position to change the structure just yet. It would mean having to redraft the entire law right now.
Ramkisoon.
Thank you, Madam Chair. Through you, Madam Chair, to the Attorney General. Harboring of a gang member, I saw you changed it to 10 under the recommendation of Senator Srikisoon. But this is quite similar to the offense of concealing a gang member, and I saw you raise it from 10 to 15. Wait, let me see. Because in the second part, we went down to say if you're a family member or if you're a parent, you would obviously have a lesser, I'm thinking a lesser sentence, because it says in sentencing the person convicted shall take into consideration mitigating factors. So I'm not even sure how many years really will be reduced for the parent or the guardian of the child, because of that is in section 2 of 12. And then if you go to 12.3, if you didn't even know, you wouldn't even be charged, because you know that provision is made in the law. So that's why I wasn't sure why we even went, if you're increasing it for 5, why didn't you just increase it to 15? Because you already put in section 2 and 3 to give weight.
And the rationale is because the treatment of what is most severe in Parliament's view and what is least severe. There is a compellability to the argument of throw natural life in and let the judiciary treat with the rest. But because we've gone for 25 years as the max, you're now obliged to disaggregate between summary and indictable, and then the categorizations, because harboring and concealing are different in philosophy.
All right, well, fine. So for section 2, what would be then the sentence for the purposes of subsection 1, where the gang member is a child and the person convicted is now a parent or guardian? What then?
That would be the judiciary's discretion.
So it would be less than 10, or?
It's entirely up to the judiciary.
Okay.
What they're saying there is that the judiciary should take a positive inquiry into the circumstances of the person who's acting in loco parentis, the person who's acting as the guardian of the child, and have knowledge of that, because our society is such that a parent may be trying to convince the child to turn himself over, etc., and may therefore not be as culpable as may be seen. It comes about in a number of pieces of law where you put in what your mitigation factors can be.
Okay, thank you.
Senator Choate.
Thank you, Madam Chairman. AG, I support you in your response to Senator Roach's suggestion, because there used to be a minimum and a maximum sentence in the narcotics legislation.
Correct.
Which resulted in a slew of litigation. And at the end of the day, it was found that that was unworkable. So I don't think, just very briefly, I don't think that we should repeat that error here today by seeking to create minimums and maximums, creating tariffs and so on. It would permit the judiciary to fluctuate wildly and widely in terms of sentencing.
Okay.
Senator just one sec. Senator Mahabir.
Thank you very much, Madam Chair. Honorable Attorney General, I really don't see too much of a difference between concealing and harboring, because I ask myself, if someone harbors a gang member, he has to provide some measure of concealing. And so we have two different sentencing for harboring and concealing. And I understand what you're trying to do in 12. I think in 12, the law intends that if a person who is connected in some way with the gang member harbors, and I think you have the intention of a relative, since we are going to have a definition of the relative in the definition section, I'm wondering whether it would not make for better law to have in clause 12 a relative who conceals or who harbors a gang member or gang leader will face the 10 years. And in 13, then we can go with anyone who conceals, other than a relative, will get the 15-year sentence. Because unless there's a very clear difference in law between concealing and harboring, I can't see the difference in English. So I'm just wondering, for your consideration, whether in 12 you will change person to relative and keep 13 as is.
May I? Person to relative would narrow the application of the law, because relative would have to be considered either by way of an express definition, which we've now drafted for another clause, or by way of judicial interpretation, whereas a person is just a person. Everybody is now liable to the application of this law.
But Honorable AG, you see, when we put person, we have two sentences, one for harboring and one for concealing. It has to be it's not clear to me, it may be clear to others, but it's not clear to me that you can harbor without concealing.
There's a term of art. Concealing takes it to a slightly different level, where you actively take steps to hide that person. You didn't put them up, and when the police arrive, you say, well, yeah, look him in the back room. Police arrive and, no, he's not here, I have no idea who he is, and he's hiding under the bed, and you lock the door, and you covered him up, etc. So concealing is a very different thing from harboring. Harboring may involve, okay, he's in the back room. That sort of approach.
Senator Roach, you wanted to say something?
Thank you, Chair. Just to respond, just a bit of clarification between what Senator Chu said in support of what you were saying based on what I had raised. I had deferred, of course, to what you have said in terms of the comprehensively and so on. But the thing is, you have a judicial sentencing policy. Is it in existence? Would that have been in existence in the time that Senator Schultz is speaking about?
It wasn't a publication then, but it was in existence.
Right, therefore. So if you have such a thing as a sentencing policy by the judiciary, certainly I can answer and address what went amiss before.
So there are two mischiefs that Senator Schultz correctly referred to. Correct me if I'm wrong, was it Mr. Justice Rajkumar who gave the decision in that particular case? That's the drug aspect. I don't remember offhand, but in any event, the point is avoiding a frontal litigation approach by people complaining about the law itself before the law is even applied. The review of the law, the constitutionality of the law, don't apply the law to me. So one is to avoid the litigation on that end. And then the second aspect is a slightly different one, which is how do we formulate this particular structure in the manner that we have right now. So the particular purpose right now is to try and keep it simple, to try and put it into effect. The overall rewording and restructuring of the law will come about with a deeper product. What we're anxious to do is to get judicial interpretation on the books. It wasn't until recently that Jamaica had its first proper anti-gang conviction, notwithstanding having the law before us. Similarly, we have 33 matters in the High Court and 40-something in the magistracy that we're looking to see can actually bring about some jurisprudential assistance locally. So again, the advocacy is to leave it the way it is, at least for now, whilst we look deeper, knowing that we have the sunset upon us.
And Attorney General, I'm quite satisfied with that approach, right? But I was just to put on the record as such that, I mean.
And appreciate it. Thank you.
So, yeah. So, honorable senators, the question is that clause 12 be amended as circulated by the Attorney General. Those in favor say aye. Those against say no. The ayes have it. Honourable Senators, the question therefore is that Clause 12, as amended, now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 12, as amended, now stands part of the bill.
Clause 13.
Honourable Senators, the question is that Clause 13 stand part of the bill. Now, Honourable Senators, there are two separate amendments proposed. One is on behalf of Senator Mark, and the other is by the Attorney General. Senator Mark, may I invite you to state the purposes of your amendment?
Yeah. Yes, thank you, Madam Chair. Madam Chair, this is one of the most contentious clauses among many, but one of the most. And it has to do with the concept of reasonable suspicions or reasonable belief. And we have a situation in Clause 13 where you would see in subclause 2, where the police officer, instead of coming with reasonable grounds, which would give the subject, or which would preserve the subject liberty to some extent and rights, the police officer under this legislation is operating under reasonable belief or suspicion. Now, in those circumstances, we are dealing with what is called conjecture. We are dealing with subjectivity and the inability to provide proof. So if you look at Clause 13.2, Madam Chair, you will see where the police officer making an inquiry and seeking the whereabouts of a gang leader. And the police officer is indicating to the person who is in contact with that the person must reveal. And if the person does not reveal the whereabouts to the police officer, then that could be a charge. Now, the police officer is assuming that this individual knows where the gang leader is or where the gang member is. And Madam Chair, this is subjectivity at its worst. And this will be subject to abuse in the most serious way. And Madam Chair, I have proposed in my amendments, if the police is coming to determine the whereabouts of the gang leader, it has to be assumed that the police officer has reasonable grounds to believe that the individual that he's interviewing knows of the whereabouts. But in this country, police picks the information, they will pick you up, they'll carry you for a drive, take it to the police station, and then get evidence. The system cannot work that way. The system has to be working, especially this is what is called unprecedented legislation, Madam President. Okay. So what I am suggesting for the consideration of the Attorney General is that the police officer is saying that you know where the leader is or where the gang member is. I am proposing the amendment to this clause 13.2, and I'm adding that the words after located, unless the police officer can provide evidence that the person has knowledge of the whereabouts of the gang leader or the gang member at the time of the arrest. There has to be some evidence. This cannot be whimsical or arbitrary, Madam Chair. Otherwise, innocent people are going to go down the chute in this situation. So, Madam Chair, whether we come to clause 13.2, you come to clause 13.3, and you see again, Madam President, subjectivity invading the environment, where the police officer is investigating the commission of some offense, and if you don't reveal certain things to the officer, he's assuming that you have knowledge. And again, Madam President, you know, I understand in the United Kingdom, in the 18th and 19th centuries, this concept of reasonable suspicion was more in vogue because of the underdevelopment of the judicial system, the police system, and even, Madam President, the police and the judicial system. But in the 21st century, nowhere are we seeing, as in the Police Service Act, that a policeman is going to, on reasonable grounds, take action. In the legislation, Madam Chair, it is on suspicion. So again, in 13.2, the amendment is as follows.
Yes, Senator Mark, I think you've laid out your case, because the amendments for 13.2 and 2, 3, and 4 are all similar.
Yeah.
Yes?
So, yeah, but Madam Chair, I'm just making the point that we have to avoid, I want to emphasize this, we have to avoid the police using subjectivity in order to arrest and charge innocent people. And this is where I want the Attorney General to pay attention, because we are going to find ourselves, Madam President, in some expensive lawsuits. And this law that we all hope will work will backfire. So, Attorney General, these are some of my concerns, and I'm saying let the police have the evidence. Otherwise, do not go and ask somebody things that they don't know.
May I have other comments on Senator Mark's proposed amendment? Senator Richards?
Thank you, Madam Chair. Just a question to Senator Mark. In his submission, does he have a particular agency or person that this officer provides the knowledge of, or to, sorry?
I didn't repeat that for me.
Do you have, in terms of your submission, do you have an intention of whom should this police officer provide the evidence that that person has knowledge of the whereabouts of a gang member or gang leader, sorry?
When I say evidence, it's in the context of this. A police officer must have reasonable grounds to go to a person's home to maybe engage in the possibility of an arrest. There must be certain bases. There must be a test that he must exercise in going there to arrest someone. And therefore, the grounds for arresting that person must be based on some kind of evidence, some kind of information, some kind of surveillance. So he could say, well, look, for the last 3 or 4 weeks, I have collected surveillance evidence. And on that basis, I am certain that this individual knows the leader because I have the evidence before me.
Understood, Senator Mark. Just through you, Madam Chair.
Yes.
But to whom should the officer provide this evidence of the knowledge?
I think Senator Richards is asking a very pointed question. Senator Richards wants to know, based on your proposed amendment, to whom should the police officer present this evidence?
Well, if the police officer, the police officer is going to present the evidence, obviously, to the courts in the final analysis. That is where it is going. But I'm saying, Madam Chair, that if you're going to arrest someone, you must be able to have reasonable grounds for arresting the person.
Yes.
That is the point I'm making.
Any further comments on Senator Mark's proposed amendment? Senator Ramdeen?
Attorney General, these are very...
Senator Ramdeen, if I could just say one thing. The Hansard reporters are having a little difficulty hearing.
Oh, sorry.
So if we could all just speak up a little bit.
Sorry.
Yeah.
Attorney General, this particular section and the offense that is created by subsections for which Senator Mark has provided these amendments are very unique offenses having regard to the ingredients of what needs to take place for someone to be liable, that a question has to be posed, there has to be a refusal to provide information, and there has to be some kind of evidential basis, which is what Senator Mark is going at. My concern is a little bit different.
Ramdeen, let's not deal with your concern just yet. I am inviting comments on the amendment proposed by Senator Mark. I will then ask the Attorney General to answer what Senator Mark has presented. So if you're not in support of what Senator Mark has his amendment, we will deal with that separately if you're not going to make a comment on that, okay? So let me just invite the Attorney General, therefore, to respond to Senator Mark's amendment, proposed amendment.
Thank you, Madam Chair. I do understand Senator Mark's fulminations. I'll start off by saying that this is a replication of the previous law, and it has been in existence, therefore, for a full 5-year period without the need to be troubled. It didn't form the basis of any concern at the Joint Select Committee of the last Parliament, which considered that law and which put the very terms into effect. That notwithstanding, however, I wish to perhaps allay my learned colleagues' fears by first of all speaking to the fact that the subsections 2 and 3 both incorporate the specific words knowing and knowledge, despite knowing where that person is located in subclause 2, and despite having knowledge about the offense. This express reference to the term knowledge and knowing requires that he who alleges must prove. And he who alleges and he who must prove in a criminal court is obliged to achieve the standard of proof beyond reasonable doubt. The Privy Council has cleared up for us on umpteen occasions for several hundreds of years, post-1935 appeal cases where the golden thread of innocence being paramount was redefined, and that one is innocent until proven guilty. Post that particular position, the courts have really had a careful time in analyzing the sufficiency of knowledge. There is the literature that tells us that knowledge may be subjective or objective, or in fact may be a cross between the two, depending upon the type of circumstances. But the burden upon the prosecution in proving knowledge is always there. The remedies available to the accused, who may in fact be a victim, Senator Mark is looking at the proportionality of victim rights, is to be found, these remedies, in malicious prosecution or in false imprisonment in particular. And again, there is a plethora of jurisprudence which speaks to the standards and proof which must be brought forward in these particular matters, malicious prosecution being slightly different from false imprisonment. In the round, therefore, it would be perhaps too limiting to adopt the amendments proposed by my learned friend, mainly because of the question pointed so squarely by Senator Richards. In expressing the language at the tail end of both subsection 2 and subsection 3, as Senator Mark proposes, the issue of the knowledge of the prosecutor himself, of the policeman himself, falls into position. And regrettably, I think that that is to curtail the operationality of the law unduly. I think that we should find comfort in the standard of proof, the burden of proof, and in the jurisprudence which prevails in this arena.
The concern remains. I'm not convinced by what my learned colleague has said, and I would just indicate that the proof of the pudding is in eating. And you're going to find a lot of innocent people being taken down, first for 3 days and then for 14 days. And then because of the vagueness of this arrangement, when they win their cases, Madam Chair, you're going to have we, the taxpayers, being called upon to foot those bills. I just want to put on record that this particular provision in the law, the clause, is not sufficiently tight, and it is too loose, and it is going to bring about a lot of arbitrariness on the part of the police, and we will pay a heavy price. But that is my submission to the AG, through you, Madam Chair.
Madam Chair, just one last point. The dicta of Mr. Justice of Appeal Barrow in the Kevin Stewart case is squarely on point as to what must be reasonable in the mind of the arrestor. And therefore, Senator Mark's concerns have in fact been addressed by our own local courts up to appellate level. And therefore, I regrettably don't share the same concern as my friend.
Senator Mark, your proposed amendment at C is a little different from A and B. So would you like to just elaborate on C?
That is for C.
Yes, yes. 13, yeah. Clause 13 at, yes, but it will be subclause 4. Your C is in respect of subclause 4.
Yes. Yeah. Again, Madam Chair, what I'm saying is that this is again subjective, because they are assuming that this clause is assuming that the person ought to, the clause is saying in defense, a person charged with an offense, but if he proves that he did not know or could not reasonably have known that the person he was concealing was a gang leader or a gang member.
Right, but Senator Mark, your proposed amendment really is adding the words at the time of the arrest after the word proves. So it's a little different from what you said initially for the other subclauses. Do you want to add anything else?
No,
okay. All right, so who wants? Senator Crease?
Yeah. The problem I'm having with this...
Senator Crease, could you just bend the mic forward so that we can hear?
Yeah.
Yes?
Thank you. The problem I'm having with this is does not reveal, which I find is a strange description of a crime as opposed to lying to a police officer. And I think the two are poles apart because...
Okay, but Senator Crease, if I may, that doesn't fall. We are dealing with the amendment proposed by Senator Mark. So may I deal with this, and then I will invite further comments because there is an amendment proposed by the Attorney General as well. So, Honourable Senators, the question is that Clause 13 be amended as circulated by Senator Mark, on behalf of Senator Mark. Those in favour say aye.
Aye.
Those against say no. No. The noes have it. Therefore, this amendment, as circulated on behalf of Senator Mark, is not approved. Honourable Attorney General, would you like to discuss the amendment that has been put forward by you?
Should it please you?
13?
Yes, please. Madam Chairman, we propose in Clause 13 that we treat with the offence of concealing a gang member differently from that which we had proposed for harbouring, and that in fact we improve the sentence from 10 years to 15 years to demonstrate the odium which we would have in that more positive step of concealing as opposed to harbouring. So it is to take it 5 years above the prescribed sentence for harbouring. So it's really a very simple demonstration of Parliament's odium with respect to the concealing of a gang member, making it obviously different from concealing.
Senator Crease, you can ask the Attorney General what you had raised.
Right. I felt normally in most jurisdictions, the crime is to lie to law enforcement. But here we are saying does not reveal, which I find not to be on the dead level, to be quite frank.
Fighting with the microphone, I apologize. Madam Chair, if I catch what Senator Crease is saying, he's looking at the use of the word reveal. Reveal not being I specifically lied or I didn't inform, but being something somewhere in between an omission and a commission. If we were to reflect upon the Perjury Act, there's a positive statement. But the intention here, because we're treating with concealing a gang member, is placing a positive obligation upon the person who is alleged to have committed the offense of actually taking a step to inform. And therefore we fall upon the literal interpretation of reveal, including both the passive and active context. In those circumstances, we felt that it would be open to the court to consider whether the prosecution had proved this beyond reasonable doubt as it's required to do. So we were comfortable. We had repeated the very formula used in Section 10 of the 2011 Act, and we were proposing that it be maintained.
Senator Ramdeen.
Madam Chair, Honorable Attorney General, through you, Madam Chair, when you look at the nature of the offences that are being created by subsection 2 and subsection 3, they are offences where the refusal to give information when confronted by a police officer is what forms the crux of the offense.
Yeah.
And my concern is that in the environment that we exist in today, where an officer confronts someone in either of these situations, to borrow the words of Senator Mark, there will be some degree, whatever may be the quality, there will be the officer has to have some degree of information to put the question and expect that an answer is given.
Yeah.
And it is the refusal to give the answer with the knowledge of the information that creates the offense. My concern is that it is, while I understand the offense, I think that we should provide some kind of safeguard to the person who is being the subject matter of the inquiry by requiring in the law itself that the officer put into writing the inquiry that is made and the response at a contemporaneous time when that is done. Because what you will have, or what I can foresee, don't say what you will have, what I can foresee is that you will have an officer who will go on an inquiry and may not even confront the person and then come and charge that person with the failure, because it happens every day. And we must cater in the legislation. You can't cater for somebody acting with bad faith or with malice, but you can circumscribe the legislation in such a way that you provide a safeguard so that if the person, you put a question to him, where is Mr. Ramdeen? The person doesn't give you that information. It then turns out that he had the information for that person. Where under the police standing orders, after Frankie Budram, where a confession is given, an oral statement, an oral admission is given, the law is that he must put it down in writing, whether it be in the station diary, the pocket diary, or whatever. But why can't we start prescribing these things in the law so that all it takes is that an officer who is going on an inquiry for this type of offense will have a standard form that he will put, this is the question and this is the response. And that will provide the contemporaneous evidence that will help the prosecution in proving the offense, and will also be a safeguard to the person who is accused, because that person will have to sign whatever it is. So if he stays silent, the officer will write it down.
Senator Ramdeen, I think the Attorney General understands what you are raising. Senator Choate.
Thank you, Madam Chairman. I just wanted to support what Senator Ramdeen is proposing. And I think it is because when police officers go out, let's say, on an exercise which includes a search where they are looking for someone, the person who is arrested may not know who is the officer who is asking him any question, and as such may not be able to properly, or he would not be given the opportunity to say, well, no, I didn't make such a statement to that particular officer. I don't even know who that particular officer is. So I think that the safeguard of having a record made and kept, an official record made and kept of what transpires in such a situation is absolutely invaluable.
Attorney General.
Madam Chair, I welcome the submissions of my two learned colleagues. We are contemplating certain improvements to the Evidence Act. We are also insisting upon a redrafting of the judge's rules, which is in fact a work product which the Criminal Justice Advisory Team from the UK is working on as we speak. My learned friends propose that we start something which is useful in this law and continue in others, which is where we prescribe a formula for utilization. Unfortunately, however, Madam Chair, the current law operates, because this law is fairly similar to other laws, by articulating measures, judges' rules, practice directions, etc. In those circumstances, I'm loath at present, without further consideration and without having a precise formula as to what ought to be the wording to capture the mischief in these circumstances, I'm loath to move immediately on this. Again, I come back to the pulling of the thread on the tapestry, but remind that we are proposing that we have a sunset provision on this particular law. It would allow us, from a policy perspective, to look at where we are in evidence as we are right now. So I'm not quite sure if I'm yet in a position to find the formula on this piece of law to be applied elsewhere.
Honourable Senator.
Madam Chair, you can assist me with this. In the circulated amendments by the AG, there's a small typo on the numbering of the clauses.
Yes,
so
3 and 3 will be
four.
corrected by
So
consequential
just for you all
amendments.
to just take note of it. Thank you.
Soon forgive me, but
in the circulated amendments, so the original bill has 1, 2, and 3, and 4, but in the circulated amendments, there's 2 trees. There's 13.1, 13.2,
in the bill it's
13.3, and
it's 4, but in the marked up version it was 3.3.
Yes. Okay. So just want to make sure that going forward it is 13.4 and not 13.3.
okay. So, honourable senators, I will now put the amendment as proposed by the Attorney General. So, honourable senators, the question is that clause 13 be amended as circulated on behalf of the Attorney General. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Senator, the question is that clause 13 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 13 as amended now stands part of the bill.
Clause 14.
Honourable Senators, the question is that clause 14 stand part of the bill.
Madam Chair.
Just 1 second, Senator Mark. There's one amendment circulated to clause 14 on behalf of the Attorney General. So, Attorney General, can you just briefly tell us what the amendment is seeking to to do?
Sure. Yes, Madam Chair. In Clause 14, we propose in 14.1, 14.2, and 14.3 that we adjust the prescriptive terms for the offences from 15 years to 20 years, from 20 years to 25 years, and from 20 years to 25 years. Again, taking care of earlier amendments proposed where we adjusted time frame prescriptions for offences. In the debate, senators felt very strongly that there should be no offer of a defence for persons charged with an offence under 2 or 3. And I should remind that this is recruiting a gang member, and 2 and 3 dealt with where the gang member was recruiting a child. Honourable senators felt that there should be a heavier expression of the odium that Parliament feels in relation to this, and offered the removal of the defence as to child, being known to be a child or reasonably known to be a child. And those are the amendments in the round.
Senator Mark?
Yeah. Madam Chair, I was concerned about the Attorney General is saying that the Senate proposed that these sentences be increased.
No. I said we amended this. When we pulled at the tapestry earlier, 10 to 15, 15 to 20, etc.
Okay.
It caused us to have to adjust other formulae coming later down because there's a matrix as to how you apply the clauses. So it wasn't the Senate. As a result of earlier submissions, we had to treat with the rest of it this way.
All right. So, Madam Chair, I'm asking again, the Honourable Attorney General, how did we arrive at these changes to the number of years? What's the rationale for these changes? And may I also inquire, Madam Chair, through you, I noticed later on we have fines, but in the earlier sections of the law, this bill, it is only sentences. Have we forgotten to include fines, or is it a deliberate policy on the part of the government to leave out fines and just incarcerate people? I'm just trying to find.
Yes, Attorney General.
I'm compelled to remind Senator Mark that we arrived in the Senate as a result of a process which the leader of the opposition put into place, where the leader of the opposition prescribed a policy which she said her party would support. So it isn't that the government has come here with a free will, per se. We have been circumscribed by the laws that previously stood and by the expressed desire of the leader of the opposition. So I want to remind Senator Mark that it isn't that we came here with free will. Had it been free will, you would have seen a lot more. Standing in the Senate right now, as we do, the answer to where do these fines come from, where do these offence prescriptions come from, rising tides float all boats a little bit higher. And having raised the penalties from 10 years to 15 years and 15 years to 20 years, there was a commensurate floating upward in these provisions as we've expressed them here. As for the utilization of fines, I come back to where I first started. The expressed approved policy of the leader of the opposition on behalf of the United National Congress was and is what is contained in this bill. We require a 3/5 majority. The opposition supported this bill in the form that it has come in the House. So therefore, I have not come here with the most liberty possible.
Honourable Senators.
So you're saying that the whole question about fines that were later on outlined in this legislation, the leader of the opposition agreed with fines in one section dealing with $100,000 or anti-imprisonment for 20 years. But you're saying that the leader of the opposition prescription for section 14 or clause 14 was to increase the number of years from 15 to 20, from 20 to 25, and from 20 to So that is what you are saying. You're putting on record.
No, that is not what I'm saying.
So how does the leader of the opposition
Madam Chair,
come into this?
This is important to clarify, if you'd permit me. The bill as it arrived in the from the House of Representatives to the Senate came here for debate.
Yes.
That bill arrived in the form that it did by unanimity. All persons in the House voted. It took us 3 attempts to get that vote right. Failed on the first 2, on the third occasion it passed. When we had the debate in the Senate, this House standing apart from the House of Representatives, honorable senators across the board requested certain improvements and amendments which we have reflected here. So yes, a clause came at 10 and we pushed it to 15 because Senator Shriki made the amendment. But the fact that it came with 10 without a fine is the truth. From the House it came at 10 years without a fine. It came at 15 years without a fine. The place where we've introduced the fine is in the new clause to treat with tipping off, which is a specific recommendation coming from Senator Ramkisoon. And that is something which we find merit in, and that's where we propose a replication of some of the formula used in the Proceeds of Crime Act. So let's be careful to get it right. Certain aspects of the bill arrived here with no fines attached to them, and that is preserved. What the value is, 10 versus 15 years, is now subject to the Senate's consideration. But it is true to say that the bill that it arrived here arrived with a unanimous position driven by the opposition's insistence as to what the bill should or should not contain.
Senator Mahabir.
Thank you very much, Madam Chair. Madam Chair, I'm reading Clause 14, and I'm reading it together with Clause 7. In Clause 7, Honorable AG, it says that a person who encourages a member to join a gang is liable on conviction on indictment to 25 years. Clause 14 says that a person who recruits, I think encouraging is a lesser stage from actually recruiting. And you are recommending in 14.1b that the recruiter, so the encourager in 7 faces on indictment 25 years, and the recruiter on indictment faces 20 years. I see an inconsistency. Why don't we in B also have a 25-year charge for the recruiter as well?
Good point, because the maximum suggested so far has been 25. So we kept 25 for the child, and we went 5 years lower for the recruiter. And it's because we're working with this false ceiling that arrived from the House of 25 years. Okay. And so therefore we had to disaggregate the treatment of child, because we couldn't take the child to 30. We kept it at 25.
But AG, that's my point. For 14.1...
Yes, the comparison between 7 and 14.1b shows 25 versus 20.
But 14.1b does not refer to the child. 14.1a and b are not child-specific.
We can reduce 7 to 20. If you're looking for harmony, and you're saying that 7 is higher, as it says 25 years, right, and 14.1b says 20 years, well, then it's open to us to harmonize it to 20.
Right. Well, my point is, why harmonize to 20? And the reason is, you see, 7 encourages, 14 recruits. Encouraging, in my mind, unless I am way off the mark, is simply telling someone about the glories of gang life and how, in fact, it is. And he can get 25 on indictment.
It also includes facilitation of the quote-unquote Mr. Big.
Right.
So because there were large people hidden behind the gang activity, as Senator Choate put it, these gang leaders report to someone, the profiteer. So because on the one hand it could be as low as you have just suggested, it can also be as high as the quote-unquote Mr. Big who's funneling or paying for these activities. And because the law is not prescriptive for every single formula that one can find, we have therefore used a framework approach to the expression. So if the sole mischief is 25 versus 20, and one wishes to have harmony, we can treat with that. The reason why we put 20 here in 1B is because we treated with the maximum for the child at 25.
Okay, but you see,
Senator Mahabir, perhaps may I ask you?
Yeah.
What are you proposing for clause 14?
I am proposing that what holds for clause 7, which is encouraging, which is 25,
yes,
also holds for the actual recruitment, which I consider to be equally pernicious to encouraging. And I can't see the merit in 20 as opposed to 25. That's just my position.
Then the obstacle of something which is more pernicious, which is the treatment of a child, falls into debate. So are you comfortable, therefore, with the entire thing being 25? No more special odium attached to the child?
When we come to 14, not 14.1 A and B, when we come to 14.2, I am very much on board with you with respect to a person who recruits a child to a gang, commits an offense, and is liable to these particular charges, fines you are laying. I think there should be a difference when you are dealing with a child, but 14, in my mind, does not deal only with a child.
May I ask specifically,
Yes.
Senator Mahabir, 14.1A?
Yes.
What is your proposal?
I would like 14.1, you see, who recruits, to be consistent with 7. A person who recruits another person to a gang. You see,
yes, I'm sorry, I am interrupting because 14.1A talks about summary conviction.
Right.
And B talks about conviction on indictment.
Yes, right.
Clause 7 dealt with a flat 25 years.
On indictment only.
On indictment. So
Right.
is your proposal, therefore, that B on conviction and indictment be for 25 years?
Yes, that is it.
Okay. Attorney General.
Then my difficulty is the treatment of the child. And I asked that question. I haven't had an answer to it.
Well, I think at some stage we have to make our own answers, and at some stage we have to come to a determination. So, the Attorney General, you have circulated your amendments. Senator Mahabir has not circulated an amendment, but is suggesting one. I would therefore ask you, what do we do? Is it that we defer this clause and come back to it because you are considering Senator Mahabir's proposal?
Well, Madam Chair, most respectfully, and I didn't want to cause my learned friend any upset, I think that because we've treated this with the understanding that so far the maximum is at 25, I'd prefer to leave the clause as is.
Well, then let us therefore now deal with the amendment as proposed by the Attorney General. So, Honourable Senators, the question is that clause 14 be amended as circulated on behalf of the Attorney General. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Senators, the question is that clause 14 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 14 as amended now stands part of the bill.
Clause 15.
Honourable Senators, the question is that clause 15 stand part of the bill. There are three amendments proposed. Senator Ramkissoon has circulated an amendment. Senator Mark has circulated an amendment. And the Honourable Attorney General has circulated an amendment. Oh, Senator Ramkissoon, I'm being told, actually is a new clause 15. So we will deal, that's not to be dealt with now. So we're actually just dealing with Senator Mark and the Attorney General. Senator Mark?
Yeah, Madam Chair, having regard to what we had discussed earlier, in terms of dwelling house, where I would want to withdraw this amendment.
Honourable Attorney General.
Should it please you, Madam Chair, the proposal that we have circulated for clause 15 is to harmonize the standard that we're going to use here, and we're migrating to reasonable ground. The original version had put reasonable cause. The Law Association had expressed concern that there was a lack of harmony and an inequality of treatment, as one reflected upon clause 15 and clauses 16. And what we've sought to do is to treat with that in a more consistent fashion. We therefore propose on the first, in the first substantial amendment that we replace subparagraph 2 in the manner of wording circulated, incorporating that there is satisfaction by the magistrate of considering evidence on oath that there is a reasonable ground for believing. And then on the second amendment, which is in subparagraph 3, we propose to include a building, ship, vessel, carriage, box, or receptacle flowing from observations made by Senator Choate in the course of her contribution.
Any comments on the Senator Choate?
Sorry. I'm sorry, Madam Chairman. What are we dealing with the one? I'm a little confused here. Are we dealing with the one about, which includes the clause about searching a dwelling house with a warrant? And
we're dealing with clause 15.
Which is shown in the marked up as the new 16. So you're looking at 16 in the marked up.
Yes. With respect to 16.3 then, in the
So 15, we're still calling it the old clause because insertions come after.
15.3, could we put in a sort of qualification to this? Because in a sense, you are giving the police almost state of emergency powers to enter any premises which might not be a dwelling house, to simply because they believe that a gang member is there. And this is a very wide invasion of privacy, and I was wondering, I know that in my written suggestions I think I had suggested that a warrant should be required. But in the absence of that, because I see it hasn't been taken on, could I suggest then that we put in something, a qualification to say a police officer may, with reasonable cause or unreasonable grounds, may enter without a warrant and search a place or premises not used as a dwelling house?
Would it satisfy you if I reflected upon the wording of the clause as proposed, if he has reasonable cause to believe?
Well, if he has reasonable cause to believe, really is just for the police officer to say, I had reasonable cause to believe. If you have reasonable grounds, then it suggests that reasonable grounds must satisfy some sort of objective test as to what reasonable is in the law. And that would constrain the police officer, I think, or encourage him to act lawfully.
What's your view on grounds versus? Madam Chair, may I? This clause, above all, is the reason for the 3/5 majority. It really falls to the heart of the law that's before us. The scourge of criminality by gangs is one where there's the live argument as to where one puts the fetter. We used reasonable cause because it's what we found in several other pieces of law. Criminal offenses, offenses against a person, a number of other pieces of law. I'm therefore very cautious, simply because of what the common law looks like, what judicial interpretation looks like on this ground, to disturb this clause. if we are really to get to the heart of disrupting gang activity, we do accept the sanctimony of the home. A man's home should not be invaded capriciously, and therefore we provided for the warranting. But everywhere else which is not a home is likely to be subjected to the public's access. And in those circumstances, I'm very cautious to migrate to a different formula.
Honorable Attorney General, through you, Madam Chairman, you were sensitive to the need of someone who may be charged or who may be a suspect under this legislation early on by providing for that person to be able to communicate with his attorney and so on. Now, by permitting this, you are essentially allowing a police officer to enter the chambers or law firm of anybody seeking legal advice. Person is presumed to be innocent. You are essentially allowing the police to enter, search those premises without a warrant, simply because such a person may be found on those premises?
Yes.
Well, I honestly don't see how that fits in with the rest of the legislation, because if on the one hand, you are saying we are prepared to ensure that your legal rights up to an attorney at law, which you have under the Constitution of the Republic of Trinidad and Tobago, we are saying that that is necessary and we are trying to protect that. Well, why not in this case? And what about the constitutional rights of the persons who happen to be in that same building at that time?
Well, they're mutually exclusive.
No, but this section is endangering them. Because I'm sure if police officers are of the view that a gang leader or a gang member is in a building, they're not going to go in there unarmed.
Senator Choate, the submissions made are, of course, very poignant and sharp and reasonable. But this is the crux of the law. The fighting chance for the Trinidad and Tobago Police Service against criminal activity does involve tripping upon a few rights, which is why this is a 3/5 majority bill. Not only was this a feature of the previous law and is a feature of other laws, but it is the crux of the matter. It is for this Senate to consider whether this Senate wishes to pass this law. The opposition has already said that they're willing to do it. And I do accept that this is a tough point. To be warranted causes complication. I don't understand that you're saying to go as far as warrant. I understand you to be saying migrate from reasonable cause to reasonable grounds. What I'm saying in response to that is that the reasonable grounds is a formula which is not something which I've come across in this type of formula, as I'm advised by my drafting team that have done the research on this particular point. In the Criminal Law Act in particular, the grounding is in cause. I'm therefore loath to disturb what the courts understand already, lest there be a sojourn into what the Parliament really intended on grounds versus cause. And what I'm very interested in doing is giving a fighting chance against criminality, which is ridiculing our society at present.
Well, you know, Honorable Attorney General, through you, Madam Chairman, we are permitting somebody, a presumed gang leader or gang member or somebody who may have committed an offense under this act, while he is carrying out the lawful business of consulting his attorney at law, which is a right protected under our Constitution, we are saying that a police officer may enter and simply say, I have reason to believe that that person is in there.
Yes.
We are giving the person the least amount of protection when he is acting lawfully. And we are possibly affecting the constitutional rights of privacy, depending on what kind of building you are entering, and possibly many other constitutional rights of other persons who may also be in the same place. So
I don't see that asking for an objective test is a very high ground that the government is being called upon to jump to. I think in this situation, all of us sitting here would hate to be in the situation where police officers come without a warrant, because a police officer, a police constable reasonably believes that a gang member or a gang leader happens to be in the restaurant where we are dining, for example.
Yes.
So I urge you to consider making the jump from what you have in the clause to reasonable grounds.
Madam Chair, Section 3 of the Criminal Law Act, Chapter 1004, reads as follows, and I refer you to 3.6. For the purposes of arresting a person under any power conferred by this section, a police officer may enter, if need be, by force and search any place where that person is or where the police officer with reasonable cause suspects him to be. And that's the existing law. So I don't find comfort only in the existing law. I recognize what Senator Choate is saying, but most respectfully, I'm asking the Honourable Parliament to consider balancing the rights. I never thought I'd have to say this, but in favour of law enforcement. There are remedies elsewhere when one is apprehended, when one is to be detained. This current law treats with the provisions of due process, of notification, of a judicial officer being asked to intervene for continued detention. There are the other remedies which apply of malicious prosecution, false imprisonment, lack of reasonable cause, etc. So this law doesn't stand on its own. And this is the crux of the anti-gang law, most respectfully. So I do hear the passionate plea, which I understand from a learned senior, Choate, Senator Choate. But most respectfully, I must disagree.
Yeah, I would like to support Senator Choate on this. I was going to deal with Clause 2, which is the one above, and demand a magistrate issue a warrant.
Yes,
but
we have proposed that.
I am suggesting that if the AG doesn't want to go there, then at least let us raise the test to a more objective level. And I cannot see any difficulty in the Attorney General agreeing that if a police officer wishes to enter a building, and Madam Chair, a building has not been defined, but a building is a place, could be a place or a premise outside of a dwelling house or a dwelling place. And therefore you open many buildings and offices to police invasion. We are not living in a police state.
You wanted to raise something? No? Any other comments before I invite? Yes, Senator Hussain.
Record. I just want to endorse what Senator Choate is saying, and also what Senator Mark is saying with regards to the definition of a building, because we see a lot of new establishments with respect to mixed commercial and dwelling premises. So now the police will have to make a distinction on whether or not they need to obtain a warrant to go with respect to the commercial part of the property as compared to the dwellings of the property. So I think that we need some more clarity and definition with regards to building, Madam
Madam Chairman, just one last plea, so that this piece of legislation will not appear to be inflammatory, because I have supported you in this House with respect to the provisions of this legislation. And I can see how a spin can be put on this legislation, which may take away from its effect by making people or police officers less willing to touch the legislation and to charge persons. This also means entering without a warrant because you think a gang leader may be there. This includes places of worship. And that, of course, opens up another can of worms. And if the protection of reasonable grounds, which suggest an objective test, is used, the Criminal Law Act just talks generally about arrests and arrests without warrant and that kind of thing. Not because there is a piece of legislation which uses a certain formula of words. It means that that formula should be used in this kind of legislation, which is draconian.
Any other comments on clause? Senator Richards, Senator Raful after Senator Richards.
Madam Chair, sorry. You know, I want to put on record also my support for Senator Choate's submissions in this particular clause, simply because, in addition to what she has said, I think we've been quite supportive of many of the submissions and ruminations of the Honorable Attorney General. But because, as she said, this really affects every other possible building or enclosed location in the jurisdiction, I don't see the mischief in forcing law enforcement to have a higher benchmark for operation, because it actually adds credibility when they do execute or apply the law. And I really want that to be considered here.
Just 1 second. I think Senator Raful.
Thank you, Madam Chair. I'd also like to endorse Senator Choate's point. I personally feel much more comfortable with reasonable grounds rather than just reasonable cause. And I do think it also protects law enforcement officers from the allegation of subjectivity if they are forced to make an objective point in their searches.
Just one, Senator Mahabir.
Thank you, Madam Chair. Madam Chair, I understand the passionate plea of my colleagues with respect to Clause 15. Clause 15 is really, as the Honourable AG said, the crux of the matter. But my view is that there is a sunset clause. The sunset clause is a 2.5-year sunset clause. And if it is that we are to provide the police with maximum flexibility, it has to be in my mind that the police will have a 2.5-year period in which to demonstrate that the abuse that is causing much concern to me and to others as well is going to be minimized. So I think, given the fact that there is a sunset clause here, that this piece of legislation will be subject to review in short order, 2.5 years, not a long time, my inclination, and it's a contrary one, is that I would like to see to what extent giving the police these powers will allow us to minimize gang activity in Trinidad and Tobago. And I would be supporting the AG here, although draconian as it is, but for a limited time only. Thank you.
Senator Small.
Thank you very much, Madam Chair. Permit me to just share a comment, if I'm permitted. My view on this, Madam Chair, is that I agree with everyone, that this puts in the hands of police some serious powers. My position on this, Madam Chair, that we have some serious crime going on in this country. If, perchance, the police intercept a communication that a gang leader is going to X building, and he's going to be there in the next hour, what are they to do? What are they to do? I would like the police and them to have the ability to go wherever that person is going and grab them. Yeah? So that, Madam, that is just my approach to it. I understand, like everyone else, this puts serious, I don't want to diminish in any way the fact that this puts serious powers in the hands of the police, but we have a serious crime problem in this country, and I would like to give the police every tool, everything in the arsenal to give them, to allow them to find these guys and get them off the streets. So on that basis, Mr. Attorney General, I think that while I share many of the concerns, I share all of the concerns. I have a view that I think these are tough times and it requires probably some tough measures.
Attorney General.
Thank you, Madam Chair. Permit me to, first of all, thank my learned colleagues for expressing as profoundly as they have their respective views. But let me dispel something. Reasonable cause is not subjective. It is not a purely subjective standard. That's a fact. There's umpteen dicta, ample jurisprudence to suggest that there is an objectivity to that position. The position of reasonable grounds versus reasonable cause. The main cause for concern in that migration is having officers second-guess themselves as to what this means or doesn't mean. The last thing that I want to see in Trinidad and Tobago today is an officer loath to apply the law because he or she does not know what it means. The consequence will be in application to him. That's the first point. That's the second point. The third point is there is ample proportionality in the round when you look to detention, when you look to arrest, when you look to further detention, because there's a judicial process that this law prescribes. So this doesn't stand on its own. That is also buttressed by the fact that the state stands liability in respect of an unreasonable cause or lack of genuine purpose behind the police action. And that stands in malicious prosecution, in false imprisonment, etc. So this particular position is not a purely subjective clause. That is not the case. And I want to be very careful to expressly state that. We are facing a situation with 2,454 known gang members. We're watching blood on the streets of Trinidad and Tobago, rape, mayhem, people with their video cameras showing cars that are arrested, tales of tragedy. And as draconian as it may sound, this clause has merit in a society such as Trinidad and Tobago with a runaway population. This law is not even going to have the benefit of the bail amendments which prevailed in 2010. Under those bail amendments, you could have arrested someone, started the matter, i.e. read the charge out, and 120 days and infinitum, you lock them up. That's not the case in this law right now. So we are far from what the 2011 aid to law looked like. And this is make or break. This is for this Senate to decide where we draw the line. And I can't say that as Attorney General I can have any other view than to support the law as cast right now because of the situation that we're in. I welcome Dr. Mahabir, Senator Mahabir's reminder that we are with a prescription for a sunset clause and that this law must be reviewed. But further, I'd add that that point of view is to be bolstered by the fact that there are 70-something plus cases between the magistracy and between the High Court that are yet to be pronounced upon by the judiciary of Trinidad and Tobago. Mr. Justice of Appeal Nolan Barrow, in the Kevin Stewart matter, had to consider the concept of reasonableness in that very case, which involved an arrest under the anti-gang law. And that stands as dicta to the proof that this is not a subjective case. I ask in the round, therefore, that the clause stand as is.
Honourable Senators, I shall now put the clause to the vote. The question is that clause 15 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that clause 15 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 15 as amended now stands part of the bill.
Clause 16.
Honourable Senators, the question is that clause 16 stand part of the bill. There are some amendments, three sets of amendments. Senator Shriki Soon, Senator Mark, and the Attorney General. Senator Shriki Soon, let us deal with your amendments first, please.
Thank you, Madam Chair. To the Honourable Attorney General, this clause is very much linked to the clause just discussed. And under this clause, it allows the police officer to detain. The part that concerned me was in the initial bill, that part of the, I think it was clause 3, where the person detained, it would be recorded in a custody record. To my knowledge, at that time, there was nothing that really was defined as a custody record. So it's on that note that I said that I thought, and I presented the view, that if you are going to, and as we're relaxing parts of the Constitution to detain someone, then there should be some form of formal record for detaining that person, which can not be easily displaced and cannot be changed. And one of the reasons why I recommended the form was that the police custody record is the police's records that they keep. And so if we're going to keep a record for someone, it shouldn't be in the custody, sole custody of the police, which would be the same person executing the action to detain. So it doesn't give any element of balance or recourse for the person. And that's why I'm asking for consideration for a formal form in this case, especially given the fact that the rights are being the person's rights are being relaxed in the law. So it's a check and balance.
Yes, Attorney General.
Should it please you, Madam Chair. Thank you, Senator Shriki-Soon, for clarifying the intention behind the suggested amendment. We saw merit in your observations in the debate, and they joined issue with the observations of the Law Association as well, who felt that the concept of the type of record that we had suggested was not known and that it could fall into abuse. For those purposes, we adopted the submission of the Law Association in using what one can refer to as that immovable fixture of the station diary, because the station diary is a permanent fixture in the station. We felt that it was more useful than a form because the forms have a process of learning attached to them, may or may not be found, and were divisible records, whereas the station diary is an indivisible record. The station diary is something which is not easy to tamper with and which hardly ever can be explained to have been lost. That is almost a rarity as far as I'm aware. For those reasons, we felt that the grounds had to be set out in the station diary. One is permitted the extraction of the station diary, the extraction of the record, and therefore that can be easily produced. So we felt that that allowed for a tamper-proof, as best as is possible, form of recording the positions, and to avoid the need to learn up a process of forms which may or may not be found, which can or cannot be produced, where somebody has a form and the station says they can't find the counterpart. We felt that the use of the counterpart technology was a little bit too fluid, and we went for the more certain version of the station diary. I don't know if that helps my learned friend to reconsider the recommendation for the utilization of a form, but our preference is that we use the station diary as per the recommendation of the Law Association.
Through you, Madam Chair. Madam Chair, I was in this House when former Senator Wayne Sturge made a contribution, and a station diary was entirely missing. So that a station diary being a large notebook and not being misplaced is not really a fact in terms that we should be considering it as being immovable. That's one. Two,
remember, I qualified it. I said as best as is possible, right?
The second point, with respect to that, is that the court system, usually when someone is detained here, if they're charged, it will take a little while. So that station diary has to be lodged somewhere, and it will be more easily to be misplaced. And then even present day, almost even up to most recently as yesterday, we're noticing that files are missing. And more, again...
Sorry, you're referring to?
A newspaper article where we saw...
Concerning the Attorney General's office?
I don't really
No, it was, and I can tell you that they were not missing.
Right, okay, but it's just in the public domain. So I'm saying that given that these files can be has the possibility of going missing, then what is the person who has been detained? What is his recourse of action? Then what if the reason for detention changes by the police officer, on additional charges later on? That person who has been detained has no idea initially of what he or she is being held for.
But respectfully, that's built upon a presumption that you don't have an extract of the station diary, which you do have. So you get your duplicate from the police themselves. It's recorded in that near immovable fixture. and you get an extract from it, so you have a counterpart. But you're not with a floating file of a form here and a form there. So there is still the remedy of obtaining the information from the station diary, and you get an extract, which is your counterpart.
Okay, well, let me ask a question, and those other honorable senators can help me here. How easy is it to amend an entry into the station diary?
It's not. There'd have to be a subsequent entry or a supervised amendment. There'd have to be senior officers participating, other factors, etc. It's not an easy position. I'm hearing Senator Amin say tearing out the page. Yes, a page could be torn out. What happens if you lose the whole file of forms and you say that's a fraud? What's the difference? Don't you have the opportunity right then and there to say, okay, it's in the station diary, I want my extract, you wait for your extract, you still have your counterpart diary missing, well, here's my extract, you stamped it. So form, diary, position, there's always mischief available in dark places, always.
And then my final question, Madam Chair, would be, and I don't know, and that's why I'm asking, how soon after one is detained that the extract of the police diary can be made available to
You can apply for it immediately, stand up there and wait.
Okay.
Record it in hand yourself, contemporaneous evidence. It's a feature that works.
Okay.
Usually when somebody, for instance, in a domestic violence matter, has to get information and you're going to the court, you go and you get the extract from the diary, they certify it and they give it to you, etc. So this is something, the reason that the Law Association, and it was member Prasad, Rajiv Prasad in particular, who's had the benefit of serving as a judge and a prosecutor, etc. It was his recommendation that the station diary be used, born out of practice. I mean, I took the advice rendered to me. I am not a member who practices in the criminal arena, so I'm advised by those that do. But I do know well enough in my years of practice that what I've just said is factual.
Okay, Madam Chair, with respect to the fact that a record would now be maintained, something more official than the initially mentioned in custody record, I thank the Honourable Attorney General for at least considering an improvement in the law. And as you have given the assurance that a record is made available and almost immediately for the detained person, then I will respectfully withdraw the amendment.
Thank you.
Senator Mark, you also have some amendments to Clause 16.
Yes, Madam Chair. Like Senator Shrikesoon, I am concerned about the rights of those who are detained. And may I ask the Attorney General, in beginning my response to this particular provision that I have advanced for his consideration, is there a distinction, AG, between detention and arrest? Or are we using it as our colleague from the Senate Independence, Elton Prescott, said, are we using it interchangeably, or is it a new incursion into the law?
I'm smiling because it's an excellent question. And I think if you ask 4 lawyers, you'll get 4 different answers. Senator Prescott expressed a particular view. Certainly the others that I have spoken with expressed different views. There is an apparent fluidity between detention and arrest. Which comes first, the chicken or the egg? I've had different answers for. Some people obviously assume that an arrest is a precursor to detention.
Yeah, well, Madam Chair, what I would like to suggest for the Honourable Attorney General's consideration is this. Someone is detained and maybe later on arrested and charged. But we know under the current legislation.
Or arrested and then charged. Arrested, detained, and then charged.
Arrested, detained, and then charged. But the current bill that we are debating, and at this level, the committee stage, you have this provision where when this person is detained under the law, he can be detained, or she, for maximum, in the first instance, 72 hours without being charged. And then the same police officer can go behind him, ex parte, to High Court and get an extension for 14 days. Now, the question here is that the person is detained, he doesn't have any information during that period. And that is why I made the recommendation that, like Senator Chikisoon, that we deal with some record that could be made available to the individual during that period. And when we go to the judge in the High Court for an ex parte injunction, that person who is being detained ought to be alerted. And I have attached 2 forms for the consideration of the Attorney General that would give that person who is detained some degree of access to information because of the circumstances. So, Madam Chair, this amendment is really designed to provide the person who has been arrested and detained with some degree of access, right, to information. And I'm saying that 2 forms have been advanced for the AG's consideration that can be signed off by the police officers and make available to the detainee, so that at least the detainee will have access to information and therefore he will not be in the dark. And that is why I have submitted these amendments with the accompanying forms for your consideration.
May I? Thank you, Madam Chair. I wish to join issue with some of the positions offered by my learned colleague, Senator Mark, and I do recognize the merit from which they spring. The position, however, is not so far off from that which we recommend when we come to the amendments proposed by the government. First of all, we're proposing specifically in subclause 3 that where a person is detained under 1, that is in the initial period, the police officer who made the detention shall without delay inform the person of the grounds for his detention and record the grounds for his detention in the station diary. So the person is informed, it's in the station diary can be extracted, the station diary has the reasons. We've gone a little bit further. We agree with the recommendations that the application for further detention shall be supported by evidence on oath. So we agree with that position. And we've inserted that we will propose that that be inserted in the amendments that the government circulates. So we join issue and agree with your recommendation on similar purpose, with similar purpose. But what we've also proposed, again joining issue with you, is that the person detained in accordance with subsection 5, that's where the judge is satisfied on reasonable grounds that there's need for further detention, that that person may make an application to a judge showing cause why the detention should be discharged. In allowing the person that purpose, there is an express discovery that is permitted, disclosure, and the prosecution must always disclose evidence which is prejudicial to the case of the prosecution to the accused. That is the standard disclosure formula. In the round, therefore, we agree with the substance of positions, but we have not gone so far as to give a particular prescribed form and notice. Instead, we've sought to take support from the other legs which operate at present. The diary, the extracting, the obligation to inform. You can't change the grounds that you've informed him for because it's in the diary, so therefore it's corroborated. The disclosure of evidence that the prosecution must give to the witness, etc. And then the general understanding of the court, because the court is seized of the fact that the person may apply for a ground for discharge. So we've not gone so far as to adopt the utilization of a form, again because of the learning curve associated with that and the reluctance that that may be met with, or how should I say, or the coolness with which that may be felt. Coldness, I should say, that people may not be as effusive to do as their normal provisions are. So respectfully, we've agreed to almost all of it, but we've not gone so far as prescribing forms. And we feel that that is to allow for the police to catch up to positions where we are. We do feel comforted that there will be a review of this position very shortly in a matter of 2.5 years, and we therefore prefer not to use the forms.
Madam Chair, to the Honourable Attorney General, you would agree with me that we may have to beef up or allocate some more resources to legal aid and advisory services, because as you are aware, as this act is operationalized and people and police do their work, a lot of persons would be needing access to legal services. And that is an area that I would imagine that the government would be looking at, because...
Most definitely. We're actually taking a note to Cabinet next week for the creation of the public defender system, which is a significant broadening of the legal aid services provided by the state.
Is that taking the form of a legal legislative form?
It needs no legislation. It was something which could easily be done just by way of restructuring.
Okay.
Thank you very much, Madam President. AG, with regards to the entry on the station diary, that's at 17.3b, at the end of the word diary, can we just insert, just for check and balances purposes, whether or not a senior officer present at the station could actually certify the entry that was made by the officer? Because I would imagine that there would be more of the junior officers carrying out the investigation and the arresting and the detaining of these individuals. So whether or not the head of the station can actually certify the entries made in the station diary at that point. I want to go as far as legislating, since you're not prepared to accept the form to be served on the detainee or the arrestee, that we provide for some sort of authenticity with regards to the entries that were made by the officer.
Thank you, Madam Chair. May I? The TTPS has cautioned on numerous occasions that many a law which prescribed officers beyond a certain rank to perform a certain function cause for a non-functionality in the TTPS, because the senior officer was often in charge of more than one station or at a different location whilst the station was in operation and there was a delay. They pointed to the structures that the senior supervises the junior, and also they pointed to the room for mischief in reformulating that which the junior officer had put down. So they felt that there was better chance for fairness to have the junior officer record exactly as the junior officer did, put it in the diary and not allow it to quote-unquote be doctored by a more senior officer. And I'll tell you where this has come about to be extremely relevant. In prosecuting the defense for the false imprisonment and malicious prosecution claims brought against the government for the arrests which took place in 2012 and 2011 under the Anti-Gang Act, largely in the state of emergency applications. It was a near impossibility to get the junior officers to attend to give evidence, simply because the law provided for the senior officer to do it. And therefore, the first-hand evidence fell into jeopardy, and the state had to end up paying significant damages. So whilst the caution was along the very line that you're offering, Senator Hussain, the mischief fell in that we couldn't get the first-hand positive evidence and compellability of evidence because the junior officer just disappeared, because the senior officer now had the certification on call.
But AG, if the senior officer actually certifies the entry, then the evidence becomes more compellable, because he would have been the one to actually certify it contemporaneously.
So the problem was capacity, timeliness, delay, and then avoidance of junior officer after, and also the potential modification, if I use that word, of the evidence.
But respectfully, it's just a very simple certificate that he can just endorse at the end of the entry.
I've actually received full written submissions on the TTPS for this reason. And in any event, the standing practice is that the senior officer supervises the diary on a constant basis.
Okay. Thank you very much, Madam Chair. Madam Chair, I am of the view that an arrested individual or someone who has been the subject of police action, he has not yet been arrested, should know from when the clock starts to tick with respect to this legislation. 16.2 says the time from which the period of detention is to be effective shall be the time at which the person is arrested and detained. I think it is really very vague, listening to my colleague, Senator Prescott, on arrest and detention, and as the AG indicated that there is some dispute with respect to what comes first. I'm wondering whether it would not be fairer to say that the time from which the period of detention is to be effective shall be the time at which the person is apprehended. So as soon as the police holds you, you know the clock starts to tick, and the police then must, once they have taken you in, come into the station at that point. You know my clock is ticking, I've been detained at that point.
Your apprehension is the arrest. Right. The minute the police puts the hand on you and says, let's go, you're arrested.
Okay, but I was under the impression, Honorable AG, that the police has to, a police officer has to indicate that you are under arrest. So that...
Well, yes, okay. The circumstances of arrest are always communicated.
Right. So to clarify in my own mind and in the mind of the citizens, there are young men in a particular place. The police jeep comes up and says, gentlemen, I'm acting under this particular act. Come, at that particular point, the young men say the period of detention has started. Thank you very much. That clears it up.
The minute they say get in the van.
That clears it up for me.
And somebody voluntarily steps in there because they fear that the force may be used after. Right. That's the arrest.
Very well. Thank you very much.
Honourable Senators, I'm now going to put the amendments circulated by Senator Mark. Senator Mark, you are still pursuing the amendments. I will now put that to the vote. So, Honourable Senators, the question is that Clause 16 be amended as circulated by Senator Mark. Those in favour say aye.
Aye.
Those against say no. No. The amendments circulated on behalf of Senator Mark are not accepted. I will now put the amendments circulated on behalf of the Attorney General. The question is that Clause 16 be amended as circulated by the Attorney General. Those in favour say aye.
Aye. Aye.
Those against say no. The ayes have it. The question is that Clause 16 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 16 as amended now stands part of the bill.
Clause 17.
The question is that Clause 17 stand part of the bill. Honourable Senators, the Attorney General has circulated amendments, has caused to be circulated amendments in respect of Clause 17. Attorney General.
Thank you, Madam Chair. Madam Chair, the draft as amended, I propose to have a small amendment, which I'd ask honourable members to take note of before I explain. In subclause 2, if you're with me, Madam Chair, just after the word before, strike the word making and insert instead the court makes, and the rest continues as is. And if you'd permit me now to explain the rationale behind the amendment. Madam Chair, Senator Prescott in particular felt in his contribution and recommended that we have careful look at the forfeiture provision. He quite correctly pointed to the risk of an unconstitutionality claim within the meaning of Section 13(2) of the Constitution as it related to forfeiture, and that we should not comfort ourselves simply with the 3/5 majority which we're gaining here, potentially, if the Senate supports it. He recommended for consideration, and we agreed, that we be more prescriptive with the notice, so that if property was going to be forfeited, that there be an actual dissemination of notice of the forfeiture, that a time frame be permitted for persons to introduce a claim in respect of an interest in the property, that time frame involve a submission into the relevant court which would be considering the matter. And we went further than that submission to add in the ability of the court to allow any person to be heard, notwithstanding their failure to enter their recognition of interest in property. And that's to be found in the new subsection 5, where we say, notwithstanding subsections 3 and 4, the court may give a person claiming to be the owner of or to have an interest in the property an opportunity to be heard where the court considers it in the interest of justice to do so. We felt that that was broad because one may run the risk of being excluded from the judicial consideration because you simply failed to submit the form in the requisite time or you weren't aware of it at all. In the round, therefore, we believe that the draft which is circulated significantly improves the forfeiture provision and allows us to rest a little bit more comfortably in the realm of proportionality.
Any questions, comments? Senator Ramkisoon.
Thank you, Madam Chair. I did have a question in relation to subsection 4 about the property owner, or if the owner comes forward to say that this property is now theirs. Is the state going to be giving any penalties to this owner for somewhat providing housing facilities now for these criminal activities, and if it would fall under a light of harboring a gang member?
The answer to that, if I may, Madam Chair, is potentially one can expose oneself to harboring or concealing if one is complicit in the act. But the innocent person who expresses interest in property, what we call the interpleader person, the interested third-party person, the mortgagor, the mortgagee, depending upon what circumstance you're in that context, they're not necessarily exposed unless they were complicit in gang activity of the type that we frown upon in the sections that deal with harboring and concealing. So I couldn't say yes or no. It depends upon whether you in fact did it or not and whether a charge was volunteered or not.
And just my final question, just for clarification, this particular clause deals with someone who has a property and it may have been abandoned and is being used by gang members.
Or it may not have been abandoned. It may have been, let's take a typical Trinidad and Tobago example. Somebody has, quote unquote, migrated or works abroad for extended periods of time somewhere else in the world, the United States or elsewhere. They have a relative who's staying at the home who comes and goes. The relative allows someone to occupy the home. The yard is frequented by unsavory characters, or the person who is caretaking at the home is complicit in it.
Right.
The property may find itself caught within the basket of forfeiture, and that innocent person may roll up and say, well, hold on, that's my property, yes, but I wish you to hear I didn't know, I wasn't involved, you haven't offered a charge, etc. And therefore the court will consider your circumstances and avoid the forfeiture. There are other laws that articulate with forfeiture, and they're related to the concepts of restitution under the Summary Courts Act and the Supreme Court of Judicature Act, where the concept of forfeiture and a minor point of restitution is considered, and those two also operate in tandem with this legislation.
And in a case where there's not forfeiture, so the courts will now say, after you said, hey, I'm the owner, stop, and they're deciding they're not, so this court is now going to return the property to the owner who's not there.
That's exactly the case.
And the activities can continue as is?
Yes, and let's use the easiest example, a motor vehicle, a boat, some form of mobile device that was stolen. Police impound it, and they say, right, that's forfeited property now. Hold on. That's my property, it was stolen, I made a report, etc. Yes, there's the restitution. And that's where the Supreme Court of Judicature Act for matters in the High Court come about, and where the Summary Courts Act for matters in the magistracy come about as well.
But Honorable AG, you're not assisting in any kind of You
did see two questions ago. That was your last question. I see Senator Hussain has his, no, finish your question. Is this your last one?
Yeah, it's just coming out of the response to that. Sorry, I didn't catch your eye. Now I have to remember what I'm for.
Honorable AG, you're not going. Is it restitution that you had in mind?
In relation to the first point of the first clause, which is the relation to, the convicted offense now. You're continuing to allow them, the owner now has the property back. We are not putting any clause in place to say that we want you to prevent going forward in this way.
How can one prevent someone from doing that?
From allowing
other than the formulation of the law which we have
to be used as a harbor for offences.
What happens if the person is genuinely intimidated? I'll tell you, we're about to bring a draft of law forward for home invasion, where gang members have entered into premises, thrown people out. They are old and elderly people who are afraid of the gang activity and they
We want to
leave.
protect them.
And so that secondary law which we have drafted is the type of law.
Okay. Thank you. Thank you, Madam Chair.
Madam Chair, through you, it's just a very small suggestion in terms of tidying up the amendment. AJ, we noticed that you use the word "the court" throughout. I know the court can be made to be the High Court or the Magistrate Court. So I wonder if instead of using the word "the court," we can use "a judge."
So, under the court, which is both courts, summary or indictment.
Madam Chair, while the Attorney General is... Oh.
The technocrat team, may I, Madam Chair? The technocrat team recommends that court will include the various functions of both the judge or magistrate because we may be dealing in two separate jurisdictions. I should indicate that yes. So the position is that court would catch judge or magistrate. But interestingly, what Senator Hussain has just caused me to observe is that we have only confined filing with the Registrar of the Supreme Court where it may be a summary matter. And therefore, I thank the Honourable Senator for impliedly alerting me to something that we've just spotted. So, Madam Chair, we propose that we just cause a small modification into Clause 17, and that, with your leave, may I be permitted to address you on that?
At 17.3?
We'll start with 17.2. So before making an order under subsection 1.
It'll be before the court makes an order. Those were your new words.
Yes, Madam Chair. The court may order. Well, we had it in 1. The court may order that any property used, commissioned, be forfeit. Before making an order under subsection 1. So we didn't need to include court there.
No, you had asked initially, AG, that...
Oh, yes, I see. I'm making, forgive me,
Yes.
I'm looking at the...
You've
yes, before the court,
making.
yes.
Before the court makes an order under subsection 1.
Correct. Before the court makes an order under subsection 1. Thank you, Madam Chair.
Yeah.
The Registrar of the Supreme Court... Either one first. Yeah. So let's put the lesser functionality first. So we'll put in after the word the, appearing in the first line there. So after subsection 1, comma, the, and we insert now the words clerk of the peace or the, and it would read Registrar of the Supreme Court of Judicature, and then insert as the case may be. And then it continues. And then, if you're with me, Madam Chair, in subclause 3, again, just before the words Registrar of the Supreme Court, we insert the Clerk of the Peace or, sorry, it shouldn't be the, because that's just before Registrar, or the already appears. So insert before Registrar, Clerk of the Peace or the. And it'll read Registrar of the Supreme Court of Judicature, as the case may be. Insert there.
Yeah.
And I think that's it, Madam Chair.
Okay.
So that's 2 and 3.
Honourable Senators, the question is that Clause 17 be amended as circulated on behalf of the Attorney General and further amended at subclause 2 by deleting the word making and adding the words the court makes and by inserting after the word the words clerk of the peace or the, and by inserting the words, further inserting the words after the word judicature, as the case may be. And at subclause 3, by inserting in line 3, after the word the following words, clerk of the peace or the, and the words as the case may be after the word judicature.
If you would just permit me, just one issue I just want to raise. It will be very short before we take the vote.
Did you just hear what I went through?
Yeah.
Senator Hussain?
Everybody heard you.
Continue. Yes.
Thank you kindly. AG, with respect to making the distinction with the courts, the magistrate court and the high court, do you want to include a prescription, just like the petty civil court, where if the property is above the value of $50,000, then you go to the magistrate court, and if it's anything above that, then we deal with the high court?
No, and I do understand why you're saying it, because the value of property is tied to the manner in which we treat with the offense for anti-gang. So it may involve a very large property which is treated summarily in the magistrate's court. The magistrate is treating with the forfeiture provisions. But if you use the petty civil formula of above $15,000, you've got to pitch the matter to the High Court. So it'll cause transmission problems for the case. So in those circumstances, I'd respectfully decline.
So you're looking at the manner in which the charge is laid, whether it's
yes. So
summary.
John Brown is laid with a charge which is being treated with summarily, and it's a multi-million-dollar mansion which is going to be forfeited. But it's in the summary court. That magistrate is seized of the jurisdiction of treating with it. That forfeiture, considered by the magistrate, is not something that we want to necessarily transfer. Of course, one may meet with the position, well, the value of the property ought to be treated with by a more serious court, quote unquote. However, there is always the right of appeal, which goes to the High Court and then to the Court of Appeal, and ultimately to the Privy Council. But I should tell you, this Friday, we'll be debating the criminal division, which is going to marry the two jurisdictions and take care of all of that.
Okay, thank you, AG. Madam Chair, I do apologize.
He asked most respectfully.
Senator Ramkis,
thank you, Madam Chair. In addition to the amendment, I was hoping that we can consider further amending subsection 5 to include the words after saying where the court considers it is in the interest of the justice to do so and determining a fine for maintenance of said property, to include what the AG had summarized or give the example of where owners leave, and really the Ministry of Rural Development will get some assistance in dealing with this as a state, and to deal specifically with criminal activities with gang members.
Sir, under the Municipal Corporations Act, the local government authority has the right to take anybody to court with respect to their maintenance provisions of their property. And there is also subsidiary assistance to be found in the the EME legislation. If we were to prescribe it in that fashion, we would be limiting ourselves only to maintenance aspects and then intruding upon the concept of restitution and other aids to enforcement. I prefer to keep those separate in the restitution formulae that exists in the Supreme Court of Judicature Act and the Summary Courts Act, and in another formula which we're coming about very shortly on, which is in the civil asset forfeiture regime, where we treat specifically with what happens when you forfeit assets coming out of matters such as this.
Thank you, AG. And just remember, the fear factor is what you're trying to not ignore, because the fear of these things being reported is what I was trying to capture with the amendment.
Understood.
Thank you.
Okay, so honorable senators, may I please have your attention?
Yes, please.
Because I now have to reread the purported amendments. So, honorable senators, the question is that clause 17 be amended as circulated by the Attorney General and further amended as follows. At subclause 2, by deleting the word making and including the words the court makes, and after the word the, in line 1, including the words clerk of the peace or the, and in line 2, after the word judicature, including the words as the case may be. Mm-hmm. And in subclause 3, in line 3, after the word the, including the words clerk of the peace or the, and after the word judicature, including the words as the case may be. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 17. The question is that clause 17, as amended, now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 17, as amended, now stands part of the bill.
Clause 18.
Honourable Senators, the question is that clause 18 stand part of the bill. There is one amendment circulated, and that is by you, Senator Mark. And if you can just speak to your amendment.
Yes, thank you very much, Madam Chair. Dear Honourable Attorney General, you know I follow closely in your footsteps, especially when you were here, where I am now today. I know every time matters of the kind I'm about to raise, the Attorney General was very strenuous and vociferous in ensuring that there was some negative or affirmative resolution of the both houses of Parliament. Although it is a 30-month cycle in terms of the sunset clause, I am suggesting, Honourable Attorney General, that if you would agree with me that if there are going to be amendments to the second schedule through whatever orders that the Minister of National Security chooses to pursue, that ought to be subject to some kind of arrangement at the level of the Parliament. I have submitted an affirmative, but with your leave, I'm prepared to compromise with a negative, so at least we will have before us, a negative resolution indicating what has taken place.
Madam Chair, I have no objection to my learned colleague's proposal for negative resolution. Affirmative may be a little bit taxing for parliamentary space, but if it's convenient to honourable senators in the round view, I would happily agree to negative resolution.
Thank you.
So the Minister with responsibility for national security may by order.
Well,
yes, Madam Chair.
We have Senator Mark's
version, which says affirmative.
Which I will just further amend.
Yes, please.
Yeah? Honourable Senators, the question is that clause 18 be amended as circulated by Senator Mark and further amended by deleting the word affirmative and substituting the word negative. Those in favor say aye. Those against say no. The ayes have it. Honourable Senators, the question is that clause 18, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 18 as amended now stands part of the bill.
Clause 19.
Honourable Senators, the question is that Clause 19 stand part of the bill. Senator Shriki, there is an amendment on your behalf for Clause 19.
Thank you, Madam Chair. Well, and I know this one is a contentious one, right? But, Madam Chair, my only reason for looking at this, yes, the 11th Parliament. And given that there's a lot of work being done here, and just to lose it, or the possibility of it being lost at that time, is of concern to me, because I think the bill is a good one. And then we have had a lot of expressions from senators or contributions indicating their willingness to support, but knowing that there is a sunset clause, and we may be able to come back to it. And if it's lost at that time, we may lose that opportunity, and that's my only reason.
Yes, Attorney General.
I thank Senator Shriki for recognizing the difficulties. So difficult was the concept of a sunset clause in the House of Representatives that we went through as a nation a significant amount of difficulty and time lost. The effect of having the 2.5-year period is that a government will have to come long before the 2.5-year period to debate the continuation of the law, lest one walk with the albatross of having had it collapse in the middle of an election campaign. So in the circumstances, because the two leaders of the respective political parties which the opposition and government fall under have agreed to the time frame as done. In other words, then, it's not within my pay grade to move away from the formula prescribed by them. May I respectfully ask for it to stay as it is? I do well expect that we'd have to be back here debating this long before the 30-month period has passed.
Thank you, Honourable AG. So with the intent that we would be able to revisit it before the 11th Parliament has come to an end, I do respectfully withdraw as well.
Thank you.
Honourable Senators, the question is that Clause 19 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 19 now stands part of the bill.
New clause 15.
Honourable Senators, there are two new clauses proposed. Senator Ramkisoon has circulated new clause 15, and Senator Shriki has circulated a new clause 16. So we will... The AG as well? And the Attorney General has a new clause 15. We normally do the new clauses first.
Thank you, Madam Chair. Just explain, or I have to read it.
Sorry?
You
can just explain.
Okay, just explain. All right, so firstly, let me say thank you to the Attorney General for accepting my submission and expounding on it. My only reason for not totally withdrawing is because I did not agree with his subsection 4 of clause 15. I did not understand why he would have inserted that section 4, because you can only be charged for tipping off if you know or suspect, right? And then the clause says if he provides that he did not know. So there's no need to say that, because you already said it in 1, that you can only be charged for tipping off if you know or suspect. So, Madam President, that's basically it.
Attorney General.
Yes, please, Madam Chair. I thank Senator Ramkisoon for bringing forward a very important recommendation to this bill. I think if the Honourable Senator were to look back many, many years from now when she's not a young lady, she will say that she's left her mark on the laws of Trinidad and Tobago, and I compliment her for that. Madam Chair, the rationale for the inclusion of subclause 4, even though we're not discussing the amendment by the government, is because we kept within the parameters of the known law. So the concept of tipping off as a characteristic of our law is to be found in the Proceeds of Crime Act. In the Proceeds of Crime Act, we have in Section 51 the tipping off phenomenon, and specifically that defense for a person charged with an offense to prove that he did not know or suspect that the disclosure was likely to be prejudicial to an investigation or proposed investigation, it's known. And therefore, there's been experience in relation to it. There was a significant amount of debate when we looked back. I looked back at some of the Hansard on the debate on the Proceeds of Crime Act. And the qualifications for the functionalities of the attorneys at law and the exceptions to disclosure, which we've included in borrowing from Section 51, had that particular point because parliamentarians felt that there could be mischief incorporated if that defense. Mind you, we're proposing that that is subjected to the defendant proving in a reversal of burden position on a balance of probabilities this particular point. So number one, it's known to the law in Section 51 of the Proceeds of Crime Act. Number two, there is jurisprudence which backs the operationality of that clause, standing as law from the year 2009 to today's date. And number three, it's intended to provide some degree of proportionality to what could otherwise be exploited and abused as an offense.
Thank you, Attorney General. I did look at 51.6 that did say this, but in relation to the tipping off, in your subsection 1, it says that you have to, a person who knows or suspects that a police officer is acting in connection with an investigation. So in order to even use this charge, Madam Chair, through you, you had to have a suspicion, and then you want to, in subsection 4, it says it is a defense of a person charged with an offense, subsection 1, if he proves that he did not, so you just would not be charged.
Yes, but the...
And I see your point with 51.6, but it also refers to 1, 2, and 3 in the Proceeds of Act.
So the Proceeds of Crime Act was defined, was a little bit different because of what Proceeds of Crime dealt with.
Yes.
Right? So that was a very narrow subset, that Proceeds of Crime Act. However, the defense for person charged, if he proves that he did not know or suspect that the disclosure was likely to be prejudicial to the investigation, was to take care of the fact, well, okay, I thought that I could disclose it because it was non-prejudicial. I was a fellow policeman acting alongside that other policeman went. I was reporting to a different unit. I did disclose it, but I didn't know it would be prejudicial. That sort of formula is meant to catch the innocent infringer, to provide an opportunity for the innocent infringer. So there is merit in borrowing from 51.6 of the Proceeds of Crime Act to facilitate a defense for an innocent infringer, lest everyone in the station who was acting in joint operation, the TTPS acting with the defense force or acting with the SSA, there may be disclosure inside of there that one may find oneself facing. And you may, in fact, find a wicked colleague who wishes to press a charge against you when circumstances could otherwise have exculpated you. So for all of those reasons, providing the reversal burden proof that you didn't know it would be prejudicial, you had a reason for disclosing it. I knew, but I had a reason for it. It provides for better proportionality.
Okay, Madam Chair, but I just don't understand a scenario. Oh, sorry. I can't think of scenarios that you can be an innocent tipper off.
I just gave you an example.
I just can't understand that, the example that you give, that's all. So I would have said that I did not support the subsection 4, but from the explanation and the...
But hold on, Madam Chair, I think it's perhaps important. A person who knows or suspects, a person who knows that a police officer is acting or proposing to act in connection with an investigation, which is about to be conducted for an offense in anti-gang, and discloses to any other person information, commits an offense. co-operative, a policeman, who tells another policeman something for a different purpose that is associated will be tripped in this offense. So therefore, it is important to take care of the joint task force operation. And in those circumstances, it's fairly important to paint out the fact that it's quite easy for coordinating teams to run afoul of this law. And that's the reason for the subsection 4 that we propose.
Senator Rankin, are you pursuing your amendment, your clause?
Madam Chair, it was absorbed in the Attorney General's submission.
So you're withdrawing? Okay. Right, go ahead now.
We have to do second reading.
Yeah.
Mm-hmm.
No, don't you have to put new clause and then... Honourable Senators, I just want to do this properly. So the question is that new clause 15 be read a second time. Those in favour say aye.
Aye. That's agreed by the AG.
The question is that new clause 15, as circulated by the Attorney General, be read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. New clause 15, as circulated by the Attorney General, will now be read a second time.
New clause 15, tipping off.
Senator Hussain, you wanted to say something?
To the Attorney General, AG, I don't know if it's a drafting, but it's very difficult to understand subsection 2 of the new provision. Can you just shed some light on that, please?
Thank you, Mayor.
Yes.
Thank you, Senator Hussain and Madam Chair. We borrowed directly from the language of poker in section 51. So 51.1, of course, the knowledge and then the disclosure, commission of offense. In 2, nothing in 1 makes it an offense for a professional legal advisor to disclose any information or other matter, A, to or to a representative of a client of his in connection with the giving by the advisor of legal advice to the client, or to any person in contemplation of or in connection with legal proceedings, and 2, for the purpose of those proceedings. Subsection 3, subsection 2 does not apply to any information or other matter which is disclosed with a view to furthering any criminal purpose. So what we're doing in 2, borrowing from poker, is ensuring that where a legal advisor is seized of the information and discloses that information to his client or to other persons involved with a different side of the investigation, as we will have shortly under, for instance, civil asset forfeiture, which is a civil remedy, that we don't find that the legal advisor is caught under the disclosure provision. So we wanted to make sure that that privilege which attorneys have is maintained expressly in the law.
So if an attorney has information regarding tipping off, they can freely share it with their client?
If the attorney is advising the client in relation to the matter. If the attorney is furthering a crime, then that's where subsection 3 comes in, where subsection 2 does not apply in relation to any information or other matter which is disclosed with a view to furthering any criminal purpose.
But wouldn't any communication between attorney and client will be cloaked under confidentiality and privilege?
Yes, and LPP operates so that the attorney cannot reveal that which the client has told him or her unless the client expressly provides consent for that purpose. But that's a different end of the equation. We didn't want to risk in any form or fashion a wicked charge coming against a lawyer because a lawyer acted in between the process. The rights of the advisory capacity of the lawyer, Senator Choate pointed out a little while ago, that constitutional right to have your attorney, that had to be protected and it is, of course, a feature in the Proceeds of Crime, Section 51.
Thank you.
Okay. So, honorable senators, the question is that new clause 15 be added to the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. New clause 15 now stands part of the bill.
New clause 16.
The question is that new clause 16 be read a second time. Those in favor say aye.
Yes.
Those
Aye, aye.
against say no. The ayes have it. New clause 16 will now be read a second time.
New clause 16.
Thank you, Madam Chair. To the Honorable Attorney General, I just considered the possibility of including DNA into this.
May I quickly respond?
Sure.
Having just had the benefit of debating the DNA regs on Monday, it's now foremost in my mind. This provision is part of the existing law, specifically under Section 13 of the DNA Act, which actually is a little bit broader than that suggested in your draft, where any suspect, detainee, etc., there's an automatic provision of sample without consent, and it's non-intimate. So it's a feature of the Administration of Justice Deoxyribonucleic Act 2012.
Thank you, Honorable Attorney General. So that once it could be considered here in terms of being being relevant. Well,
so what I was saying is that there's no need to put it here because that law kicks in.
Okay, excellent. So, Madam Chair, I can withdraw the amendment. Yeah.
So you're withdrawing?
Yes.
Yes. So new clause 16 is withdrawn. No. No, we're going now to the preamble.
First schedule.
The question is that Schedule 1 stand part of the bill. Senator Mark?
No, I raised these two forms when I was dealing with the amendment, and the AG had answered.
So these are withdrawn?
Yes.
I do have amendments to Schedule 1.
There was a vote taken on that, yes.
Yes, I remember.
Madam Chair, may I address you on Schedule 1?
Yes.
Madam Chair, we have circulated some improvements to Schedule 1 by adding the listed matters from numbers 29 to 46 inclusive. This was specifically to take care of observations, in particular from Senator Choate, who put it very elegantly, that we should move away from what is just referred to as street gang activity, criminal street gangs. We've added in the electronic stroke commercial side of it by including the Prevention of Corruption Act, the Trafficking in Persons Act, Misbehavior in Public Office, Gambling and Betting Act.
Could you clarify for us why this particular law is here? Misbehavior in public office, and could you show us the relationship between that and the anti-gang bill? Are you referring to what?
Yeah, yes, for the misbehavior by the police in particular, by the law enforcement authorities.
Okay.
In the event that they had acted in an improper fashion, or where there was a linkage back to that abominable unknown person who actually held public office, somebody in customs, without being pejorative to them, who was causing facilitation or other matters, immigration, running brothels and gang activity, trafficking in persons, etc. Those are all persons in public life that we could probably catch from that end of it and then take it back.
Okay.
Madam Chair, we've also lifted out, well, we've added in manslaughter. Senator Choate was kind enough to clarify the caution, well, the caution which I had, to address the caution which I had between voluntary and involuntary, and we were grateful for that. We've added in hijacking, hostage-taking, prostitution, child prostitution, causing or inciting child to engage in sexual activity, offences relating to dangerous drugs under the Children Act, offences relating to child pornography under Children Act, keeping or management of a brothel, detention of a person in a brothel, procuration of for the purposes of prostitution, living on the earnings of prostitution, meeting a child following sexual grooming. So we lifted out of the parent laws these particular offences so that we could broaden the purview beyond the street gang activity, as honourable senators had cautioned we should.
Madam Chair. And I would also assume that what you have just said earlier would be related to item 29, offences under the Prevention of Corruption Act.
Yes, sir.
So whether it come from these law enforcement agencies or whatever.
Yes.
Right, I follow.
Yes.
Pool?
Thank you. I wanted to ask about number 8 on the schedule, counselling a gang leader, gang member, or gang. Would counselling include religious counselling or psychosocial counselling, or something that could be trying to support someone from moving away from gang activity?
It's specifically from Clause 9 of the bill, which is counselling a gang. So what this refers to is the offences in the Act itself, as included in the schedule. Okay. So counselling is directly in reference to Section 9 of the Act, Clause 9 of the Act.
Thank you.
And no, it doesn't. Counselling is defined as a person knowingly counsels a gang leader in furtherance of its participation and involvement. Gotcha. So if the religious counselling was, yes, go forward and continue doing your gang activity, kill people, rape, murder, promote some obscene cause, well then yes, if you happen to be a priest or a pundit or an imam who is doing that, or a layman, well then you'll be caught. But if you're doing something else, well then it's not within the definition of Clause 9.
So it's in furtherance of criminal activity?
Yes, yes.
Thank you.
Yeah.
Senator Mahabir.
Yes.
Yeah.
Thank you very much, Madam Chair. I was just wondering what's the reason for not including money laundering, which to my mind is a major gang-related activity that is not
That's under the Proceeds of Crime Act.
Okay, right.
Sections 44, right. 43, 44, and 45 of POCA.
Very well. Thank you very much. It's included. Honorable AG, and through you, Madam President, I look at the law itself, and a gang-related activity indicated that it must be directed by a gang leader. That's under the definition section. And when I see, say, 13 listed in first schedule, threatening to publish with intent to extort, it has to be that in order for this particular crime to be prosecuted, it has to be under the direction of a gang leader. And that, in my mind, threatening to publish with intent to extort may be more of an individual activity, so that I can't see the connection between a gang-related activity and threatening to publish with intent to extort.
May I correct a misconception that you may have?
Yes.
Or maybe operating under, most respectfully, through you, Madam Chair. Yeah. Gang-related activity means an offence, an attempt to commit an offence, aiding and abetting, etc. of an offence. The conspiracy to commit an offence, here's the choiseul, listed in the first schedule, which a gang leader or gang member plans, directs, orders, authorizes, or requests. So it doesn't require the express operation solely of the gang leader. Okay. Any other gang member, i.e. more than one, acting in purpose for the scheduled matters will suffice.
Okay, so basically under 22, I had a concern with rape and grievous sexual assault entering into the schedule. Yes. It has to be directed by a gang member or a gang leader.
So if they committed the offense of rape in conjunction with a gang member, 2 or more of them, or through the counseling or procuring, etc., then they would be caught.
Okay, very well. You see, I also had a concern with respect to misbehavior in public office. You see, Honorable Attorney General, we are giving the police wide powers and powers to enter without warrants into any places other than a home in which persons may be, who have been accused of these crimes may be found. And when I look at some of these items, the misbehavior in public office, immediately I thought, well, is the police going to be looking at public officials, elected officials, members of parliament,
if they're involved in gang activity? Yes.
Okay, okay. If there's an assumption that they're involved in gang activity.
If there's evidence.
Okay.
If I may remind you, Honourable Senator, in 90% of these matters, you're going to have the supervision of the Director of Public Prosecutions, right, who under Section 90 of the Constitution has a sole discretion to even go so far as to enter and nolly prosecute. So let's assume that a matter was actually incepted. Yes. Let's say under a private indictable. For some reason, the Director of Public Prosecutions has a supervisory function that still acts as a safeguard in these circumstances.
Okay, and the last one that concerned me was meeting a child following sexual grooming. Again, I thought that this was more of an individual activity from an individual who is engaged in antisocial behavior as opposed to a gang-related behavior. Could you indicate for my own edification why this particular offense is in the first schedule?
So sexual grooming is a defined offense under the Children's Act. We couldn't do a reference to any offense under the Children's Act because that could include children in need of care or supervision, that could include parental neglect, etc. Okay. So we went instead for the severe offenses appearing under the Children's Act. Right. And grooming was one of those offenses which found itself, sexual grooming within the definition of that act, in the type of activity that we see on our streets. In fact, Senator Huggins was really the origin of this thought, where he referred to children, young ladies in particular, who find themselves inculcated into gang activity, as he put it, usually the most pretty ones in the village or community. And they are most usually, when you look to the circumstances, the victims of sexual grooming. And it was to specifically focus upon that activity. If you look at the vast number of bad boy videos circulating in Trinidad and Tobago, gold and bling and flash, it's usually in the company of some rather attractive young women. How do we treat with separating that functionality? This is one of the measures.
Okay, very well, thanks.
May I just... Sorry.
Honourable Attorney General, through you, Madam Chair. At AG, do you see the listed provisions as including in any way gang initiation rituals inclusive of sex acts? Because in many jurisdictions we've seen that sort of scenario play out.
So we
and not necessarily with
criminalized it.
minors, but
Actually, Senator Richards is referring, Madam Chair, to something which astounded me in the United Kingdom. There was a gang ritual activity which involved the rape of almost 1,000 young boys and girls in the United Kingdom. I was shocked to learn that that was in fact the case. And it was a gang ritual activity in a metropolitan environment in a first world country. So Senator Richards is referring to something which is serious. Thankfully, Senator Shriki Soon added in an act of initiation today into Section 6, where we have added that in. That's why I found it so persuasive, the recommendation made by my learned friend. And therefore, I can say that now, conclusively, notwithstanding the fact that it's not scheduled, it is certainly caught by the new Section 6(1)(d), if I remember the numbering correctly. C, the new C.
okay, thank you.
Attorney General, what about the matter of trafficking in arms and ammunition, apart from selling or being in possession of arms and ammunition and using it to commit crimes? You know, you have a very brisk trade between Venezuela and Trinidad and Tobago, food for guns. So you could have gangs organizing food in exchange for arms and ammunition. So I'm not seeing it captured here.
You're correct. I'm not aware, maybe Senator Choate can assist me, I'm not aware of an actual common law or statutory offense of trafficking in arms and ammunition. I am aware of possession of arms and ammunition, but I'm not aware as a feature of law of that. I can be guided by that. I don't know it as a concept under our law per se.
Did anybody guide us on that?
Senator Choate, through you, Madam Chair.
Well, perhaps through you, Madam Chairman, perhaps I should say, to the best of my knowledge, without consulting the Firearms Act, I cannot say that I've ever seen a criminalization of trafficking in firearms as we have for narcotics. Nor have I ever seen such a charge laid.
No, the only reason I'm raising this, Madam Chair, is that we live in a dynamic environment, and Attorney General, you are aware of what is taking place right in this environment.
I'm sorry to interrupt. May I just say, Senator Mark, through you, Madam Chair, I undertake to look at that by way of proposed amendments to other law. I think that it's something that is very interesting and can perhaps be in our firearms legislation per se. I think it's a good thought.
Now, the final thing I'd like to raise, ma'am.
Sorry. If I could just make one small contribution. I think that we may get some benefit by looking at the Customs Act, because it may be that that would fall, that kind of operation would fall or be criminalized under that piece of legislation.
Thank you, honourable senators. I'll look at it.
Yes. Attorney General, I just wanted to advise that seeing that this product that we are dealing with, although it be in the Senate, you keep emphasizing, or you kept emphasizing, it was the effort of the opposition and the government and so on. I wanted to ask whether you had consultation with the leader of the opposition as it relates to item 29 to 46, or were these newly inserted provision without the leader of the opposition consultation? Because I don't want this legislation to go sour in the context of any untoward development. There are areas that I see here that may raise red flags, as I told you a short while ago. So I just wanted to know if you had consultation, and I hope that you do, or you did, so that the opposition leader and the opposition would have been able to see these things before.
I find the question rather interesting. I'll be polite. It's for that very reason that I circulated the amendments days ago and provided track change versions, circulated amendments, etc. I understand the system of party politics to operate such that I'll consult within my own ranks and not necessarily without my own ranks. And therefore, I would hope that Senator Mark can answer his own question, because I did provide senators opposite with this material. I caucused on our team. I provided it to the entire independent bench days in advance. So this hasn't come as a surprise to anyone, these inclusion of positions. So I do hope that there is some form of unanimity across the floor. So to answer your question, no, I have not consulted with the leader of the opposition, nor would I dare to.
Okay, at this stage, honourable senators, the question is that Schedule 1 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. The ayes have it. Schedule 1 stands amended as circulated by the Attorney General. The question, therefore, is that Schedule 1 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Schedule 1 as amended now stands part of the bill.
Second schedule.
The question is that Schedule 2 or the second schedule now stands part of the bill. Attorney General, you have circulated the amendments. Yeah.
Madam Chair, if I may, for the record, taking avail of the inclusion of evidence upon oath, we've caused an amendment for consideration to the Form 1 attached to the second schedule, which is the application for detention order, where we put in the certificate of truth at the footer of the form, that I swear to the best of my knowledge, information, and belief the contents of this application are true. Secondly, we have caused an amendment to Form 2, we've caused an introduction of a new form to the second schedule, where we set out the prescribed form for the expression of interest in property pursuant to Clause 17 of the Act. And this is to meet with the forfeiture of property provisions. Thank you.
Senator Shriki Soon, you also have a
Thank you. But the form was addressed in the contribution of the Attorney General. I think it was Clause 16 with the detention order and the entry into the station diary.
All right. So having withdrawn that particular amendment, yes, okay. So it's formally withdrawn in any event, yes. Yes.
May I just cause a small adjustment to the Form 1, please, as I look at it slightly, as I look at it more carefully. In the Form 1, if we look at it together,
yes,
I blank hereby apply under section so-and-so of the Anti-Gang Act for a detention order. Please strike the words in favor of and insert against. And that would be it.
Madam Chair.
Yes, Senator Crease.
It opens with Republic of Trinidad and Tobago in the county of, and I have a problem with county.
It's the magisterial jurisdiction formula. So the application goes to a magistrate. Magistrates are set up with divisions which are done by way of county. So the magisterial court is in the county of St. George West, in the county of X, in the county of Y. So that's the formula which must be operationalized here.
Trinidad has no counties.
No, we do have counties, Senator Crease.
I think counties had been changed to another word. But what happens is that when the informations and the complaints are filled out, they still say in the county of Victoria or county of St. George.
Yes, well, there was a whole, in fact, it may come up in the debate which is next coming, in that land and building taxes, municipal corporation, et cetera, formula. There is an incongruity which is about to be solved in a more holistic way. No, unfortunately, we have to leave it, and then it'll cascade back when the other changes come.
Madam Chairman, I think because the laws with regards to these boundaries were changed way back in 1990, gradually you have to phase out the use of county. And even, for instance, in the EBC and so on, they now use in the region of instead of in the county of, and then you fill in the blank. So there's no.
Madam Chair, it's good.
I don't know if the AG has a reason for
yes, I do.
wanting to stick to it.
Yes, I do. Because in the criminal division bill, which is on the floor of the Parliament for debate this Friday, we'll be treating with the whole merger of magistracy and High Court, and in fact, we'll be reformulating how the magistracy works entirely, so that all of that will be rearranged. Oh, yes. So the judiciary is going to organize that particular aspect, and then we'll reformulate how we treat with these things.
So is it that the judiciary wishes to retain the non-existent county boundaries?
It's not non-existent. It is existent.
Yes, because, is it that they wish to retain the boundaries, from the old local, municipal?
What's important? I'm sorry.
Separation, yeah.
What's important to remember is that the 17 magistrates' courts, that's 14 of them and 3 out courts, is it, Farzana? 14 and 3. Those structures are done by the judiciary under the Supreme Court of Judicature Act and under the Summary Courts Act. And they've divided themselves actually into counties. That's the judicial setup of its positions. Counties still apply, and I say so because in conveyancing, you still work with ward reference and in some instances county reference for certain purposes as it relates to municipal corporation or land and building taxes or valuation of land formulae. So I agree, it's in a mess. Which law applies and how it is going to be done is going to be sorted out in the local government legislation, but from a jurisdictional court perspective, it'll be treated with under the criminal division arrangements that we will do very shortly, as soon as this Friday.
Senator Mark.
Attorney General, Madam Chair, I know that we have closed off on a particular matter here, but I really do not want to cause any unnecessary delay. But I wanted to ask the Attorney General, well, I want to ask the Chair.
Senator Mark, are we dealing with the second schedule?
And this is what I wanted to ask you, if development has taken place, which that has caused me to ask you if I could seek your indulgence.
What exactly is the nature of the indulgence?
I'd like to go back to Schedule 1. Where would you all leave?
Does it impact the second schedule if
Yeah.
we go back to Schedule 1?
Yeah, and it's a very serious matter, and I wanted to ask you if you could suspend for 10 minutes.
No. I'm trying to let us arrive at a certain point in this bill, and then we will come back, we will take a break,
Yes.
we will come back because there are two clauses that have been deferred. 3 clauses that have been deferred, and I am trying to manage this process.
And I know
so
that you have
we
been
can,
doing,
yes.
I must tell you, Honorable Chair, you have been doing an excellent job. I must tell you, you have been doing an excellent job.
See?
I must tell you, you have been doing an excellent job, and I want to thank you. I want to thank you. I want to thank you very much. Thank you very much. But, Madam Chair, just want to engage, seek your indulgence and the Attorney General's approval. If we could just revisit Schedule 1. I want to talk to the Attorney General when we break for a little while. A very serious matter, as I could.
Here's what we will do. I will not announce a rescission just yet.
Yes.
Let the discussions take place when we take the break, and subject to those discussions, I will then make a decision as to whether we go back.
Okay, thank you.
But I do think that we should finish the second schedule.
Yeah, I have no problem with the second schedule, ma'am.
Okay. So, are there any other comments with respect to the second schedule and the amendments proposed by the Honourable Attorney General?
Yes.
You have a comment?
No, I'm in total support of you, Madam Chair, on this matter.
So, Honourable Senators, the question is that the second schedule be amended as circulated by the Attorney General and further amended by deleting the words "in favour of" after the word "order" and substituting the word "against." Those in favour say aye. Aye. Those against say no. The ayes have it. The second schedule, no, and the question is that the second schedule as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. The second schedule as amended now stands part of the bill. Honourable Senators, at this stage, we will suspend the sitting of the committee. And because I am such a generous person, and because we have done such good work, we will resume at 6:45.